Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican po, he's very much Latino.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, welcome to the Court of Public Opinion. Whoa, there's one place to be. Good morning, I am the Recovery Addict, large and in charge and not in my corner, apparently. See, I should be down there, but bigger. We'll get this figured out. There we go. How are y'all doing this morning? My background is off. Oops. It's a crazy morning. Hang on, let me turn the light on. Aziz, light. Right, good morning. Welcome to everybody. Good to have you here. Let's see, where are we? We're right over here. How was your weekend? How did everybody do? Everybody reporting in, safe, happy. I have to say congratulations to Casey TC77. First in chat today, Casey. It is your lucky day. Or unlucky, depending on how the workload goes. Because you were first in chat, we're going to punish you and sentence you to internet ownership. Everything IP-related worldwide is now your responsibility to fix, maintain, and basically train people on how to use. So hopefully you've got some free time today because you're going to need it. Casey, congratulations. We will add this to your permanent record as well. All right. How is the visit with my son and my daughter-in-law? Great. They're gone. I mean, it's not great that they're gone. I'm just saying it's going great, and they are gone. The whole family, except for my third oldest son, who is at work right now, is off at the beach. They have, I think they're down at Indian Beach. Not sure. I'm not sure if they went to Topsail or Indian Beach. But they're down at the beach enjoying the scorching hot weather, and took the body boards and the skim boards and all little shovels and scoops and shaboomies and towels, and they're down there for the day. They're going to have some fun at the beach, and then they're going to go to the aquarium, the Pine Knolls Shores Aquarium. So they're going to be having some fun there. They've got some tickets. You have to buy those in advance. It's crazy. But got some tickets and are going to be there. So enjoy the aquarium. Kids always love going there. Me, on the other hand, I am here with y'all today. And so we're going to try to catch up with some happenings of court. We've got a couple things going on that may be interesting. I know we've got a jury selection going on in Minecraft court right now.
28. Okay, how do you know 28?
Which is interesting. We might pop in on that. That we can't see the jurors; they're just pixelated people. But we get to hear them a little bit, and that might be fun to watch a little jury selection in that court, as we don't get to see that very often. Let's see. Then, full disclosure, I have not started packing, which is bad because this time tomorrow I'm going to be landing in Salt Lake City, Utah, at the airport, picking up a car and zipping up to Bear Lake. I need to do that at some point. I think I've set aside mentally, I've set aside what I need. Of course, I need like this camera and that computer, but pretty much everything else stays. I'm going to go bare, it's going to be minimalist me. I'm just taking like the Starlink and, some cables. And I'm taking a lot of cables, but Starlink wireless mic, so I'm not going to quite sound the same. It's going to sound different for a couple days. But anyway, how's everyone doing? I was looking. I don't even want to know what our real feel is going to be today. It was 105. Ouch! At 7 p.m. Melissa, that is terrible. That is terrible. Basically, move. Look for a place in Alaska. It's cooler there. All right. I think I'm going to get into hockey. This is Melissa, because it's colder. There's ice. 93 in Ohio. It's going to feel like 100. And some places are getting, what's a drencho? A drencho or something? Middle of the country today? I don't know if that's you. Let me know. What is that? All right. Happy anniversary to Melissa and Matt. That is awesome. Let me go through a couple membership things. I know I've got some birthdays to sing to as well, but we've got a few people who shared some things with us this morning that are important and cannot be missed. Why can I not scroll up? Oh, that is the top. Never mind. Sharkey, much better. Aziz, thank you. Yes, we have lights now. Thank you. Sharkey, 19 months. We know you've been here longer. Thank you. One of our OGs. Thank you very much. Also, Jennifer Juniper, another OG. Official member for 18 months. Happy Monday. Thank you to whomever gifted me a membership last week. Yay to 18 months. Luca, 20 months. Also an OG. Hello and good morning, everyone. I had a great weekend. I hope everyone is perfect. Hello to the best community in the world. Love you all. Luca, thanks for the wonderful morning message there. DSN member for 29 months says thanks and also gifts a membership promptly. Thank you, DSN. Thank you for your generosity and for your amazing support of the channel. Kim R, super sticker thumbs up. Thank you very much, Kim, with the Dolphins. Appreciate your support as well. We are going to get going with some birthdays here in just a second. Let me scroll up for just a second. Josh has brought us Susie Hat 44 and Charlie are celebrating their birthday. If anyone else needs to be on the list, speak now or forever hold your peace. Let us know. Melissa, that is awesome. 30 years anniversary. That is just really cool. Life goals. There we go.
Happy birthday. You look good.
Yes. Let's do the birthdays. Let's do that. Everyone gather together wherever you are, or just stand up if you're able. The only people who are exempt are those who are not able or are currently driving. If you're a passenger, do your best. Okay, do what you can. Stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, and warm up with me if you will. La 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 la. There we go. We're going to sing to Susie Hat 44 and Charlie. Happy birthday to you. Happy birthday to you. Happy birthday, Susie Hat 44 and Charlie. Happy birthday to you. There you go, Susie Hat 44 and Charlie. Happy birthday. I realize there are a million places you could be and a million people you could have been with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can return some of that joy back to you, make your day a little more special, or begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Whew. Wow. There you go. Happy morning.
Happy birthday. You look good.
Judge Fleischer even weighing in. Choo-choo-choos. Somebody had the definition for me. Hang on, let me go back and find it. Chris, as long as you're on the same account, like the same YouTube account, you don't lose progress. There you go. If you have a different YouTube account, it counts as a different person. All right, it's super fast straight line winds that can knock over power poles and all the crops in the area. Devastating. Oh my goodness. Straight line winds. I realize as the birthday song continues, I realize this might be a little selfish of me, but as someone who's going to be flying from the east to the west, what is a Dreco at, say, 36,000 feet? What happens up there? I'm curious, asking for my own personal well-being. Drum solo to finish. Here we go. Beautiful. Thank you all. And congratulations to Melissa and Matt as well. Yeah, what happens at 36,000 feet? Does this mean bumpy ride tomorrow? Intense, widespread, long-lasting, straight-line winds, but it is not a tornado. So it's a big, fat, wide, straight tornado is what I'm hearing. Wow. Josh, I can envision what you're going to tell me. I think it's a domestic case in that court. Strangulation. Licking is happening, right? Oh, what's going on right now? And I missed part of it. Dang it. What's going on in Licking County? I was recording part of it because Licking doesn't let you rewind, and then I lost it. Let's see. Licking County courtroom jury trial going on right now in courtroom 1. Let's pop in really quickly on 8.
After a great deal of protesting that he was not there, which you will see on camera, eventually officers did find him hiding in the attic. Now, getting back to those specific elements. So those elements are that on March 9th, 2025, in the city of Newark, Licking County, Ohio, Clarence Hurley knew that Donald Hurley had a warrant. He knew because Officer Ellis told him. And knowing those facts, he, with purpose to hinder the discovery, apprehension, or prosecution of Donald Hurley, harbored or concealed him in his home.
He harbored a fugitive.
Now, based on the familiar relationship, that might be a reason, but legally, it's not an excuse. So, based on those facts and the testimony you hear today, I'm confident, and I will ask that you return a finding of guilty on the single charge of obstruction of justice. Thank you.
All right, that was the opening statement from the prosecutor. Harboring a fugitive. We're right at the beginning of this trial. I believe it is a jury trial. Selena, thanks for the gifted membership. Sean White, 19 months, OG.
Hey everyone. He stole my line, so I won't repeat it. But I do appreciate you all being here, hopefully some more willingly than others. If you haven't served before, it is an interesting experience, and it's a great look into how the criminal justice system works. It sounds trite to say all this and to thank you to be here, but without you guys, this wouldn't be able to happen. Our criminal justice system wouldn't function the way it currently does, and you guys are the key part of that. So we actually do thank you a lot.
Defendants in the white shirt and blue tie there.
Some of the facts that you'll hear today,
towards the left of the screen.
actually probably a good amount of them, actually won't be contested. What won't be contested is that Mr. Hurley's son, Donald Hurley, had a warrant for his arrest, was seen on the street, and did run into Mr. Hurley's house. That part's not disputed. What will be disputed is that key part of the statute that Mr. Savage just read to you. That with the purpose to hinder and obstruct the discovery of Donald Hurley, that was Mr. Hurley's intention that day. I suspect what the state will ask you to do is to take those uncontested facts that Donald Hurley had the warrant, went into the house, and was eventually found in the attic, and then make the jump to say Mr. Hurley knew about all this, was lying to the officers, and was trying to prevent the officers from finding him. What Mr. Savage didn't mention, and you will see on video, is that officers were told they can come into the house multiple times to search for Donald Hurley if they so desired. And in fact, this was early on when Officer Ellis went to their house. The longer that Officer Ellis waited, he wanted to back up. Honestly, I can't remember if you mentioned a warrant or not, but they did go inside when the backup arrived. The longer that waited, the longer Donald Hurley had to go into the house and attempt to hide.
We're in Licking County, Ohio.
Now, he was found in the attic, and I believe you'll see in the video that it seems that he went straight up into the house, into the attic. There's no indication whatsoever Mr. Hurley saw him, talked to him, or anything of that nature. What you'll see on the video is Mr. Hurley come to the door. He will say, no, he's not here, because to his knowledge, Donald Hurley was not there. He did not see him enter the house. What you will hear him say is, you can come on and look if you want to. That statement, that willingness to have the officers come in and search for Donald Hurley is in direct contradiction of that element of having the intent to hinder or interfere with the discovery and apprehension of Donald Hurley. So I'm going to ask you to watch the video, see what all is said, and find Mr. Hurley not guilty of obstruction of justice. Thank you.
All right, you can't obstruct an officer as they're trying to arrest someone, even if it's your son. Let's see.
Pickles, Officer Ellis.
See how this goes down. Jade, thank you very much. Congratulations on 13 months. Good morning to you.
Remain standing and raise your right hand. You solemnly swear or affirm the testimony you should give in this case now being heard to be the truth, the whole truth, and nothing but the truth. So, God, under the penalty of perjury. I swear.
We've seen the judge and the lawyers. This is the new case. This is live.
Bradley Ellis, E-L-L-I-S.
And state your business address, please.
39 South 4th Street.
This is a business address. This is a police officer, but I muted anyway.
Thank you, Officer Ellis. Can you tell me who you're employed with?
The Newark Police Department.
And how long have you worked for them?
About 5 years.
Oh, they're wearing a band on the badge.
And what are your general day-to-day duties in that position?
Day-to-day duties would be the normal police patrol officer.
Judge is surfing the internet. You can see it in his eyes.
Are you familiar with a Clarence Hurley?
Yes, sir.
Okay. Is he in the courtroom today?
Yes, sir.
Okay. Can you identify him?
He's right there wearing the white shirt, sir.
Let the record show the witness has identified the defendant.
Show. Alita Lay, thank you very much. 20 months, OG. Also,
right,
21 months,
turning
OG
back
for
to
AZDCS
the events
oversight.
of March 9th, 2025. Do you remember that day?
Yes, sir.
Okay. Were you working that day?
Yes, sir.
Okay. What shift were you working?
I was working first shift, 7:30 to 5:30 at night.
Okay. And what were you doing in the course of that shift?
Just the regular patrol duties.
Okay. So is that driving around town?
Yes, sir.
Okay. Did that...
The defense lawyer is so
in the course
tired.
of those patrols, did you drive down Clinton Street?
Yes, sir.
Okay. And are you familiar with Clinton Street?
Yes, sir.
Have you driven down that before?
Multiple times, yes, sir.
Okay. And are you familiar with any of the families that live on that street?
Yes, sir.
Okay. Are the Hurleys one of those families?
Yes, sir.
Okay. So on this day, March 9th, 2025, did you see any of the Hurley family?
Yes, sir.
Okay. Which member of the family did you see?
I observed Donald Hurley on the sidewalk in front of the residence.
Okay. Now, were you still in your vehicle when you saw this?
Yes.
Okay. And so now, were you wearing a body cam at this time?
Yes, sir.
Okay. And is or let me go back. Also, were you wearing a marked uniform?
Just the regular patrol uniform, yes.
Sorry, yes, your law enforcement uniform?
Yes.
And were you driving a marked patrol cruiser?
Yes.
With a working light bar?
Yes.
Okay. And is that patrol cruiser, is that also equipped with a camera?
Yes, sir.
Okay.
So we might have two.
Yes, yeah. All right, sorry. Get ready. I can ask a few more questions first.
Bailiff turns on the TVs. Tammy E. Almost a year in a new courthouse, Orange, next month. Tammy, thank you very much.
You may.
I think the defense lawyer is going to just full on forehead to the
Now,
table.
right in front of you, you have what I've marked as. Sorry.
You're welcome.
All right,
Hey, baby,
so
baby.
before we get to the video, I've handed you a document that I've marked as Plaintiff's Exhibit 2. Can you identify what that is?
That is the arrest warrant for Donald Hurley out of Franklin County.
Okay. And is it signed?
Yes, sir.
Okay. Is it signed? Who's it signed by?
The judge.
Judge Carl.
All right. And is it also certified?
Yes, sir.
A stamp?
Yes, sir.
And a signature?
Yes, sir.
Okay. All right, now. So now proceeding to the video, which
Kayla,
I am
thank you very
identified
much.
as Plaintiff's Exhibit 1.
He has authenticated it.
All right, can you see an image on your screen?
Yes, sir.
Now comes the foundation.
Okay. All right, can you tell me what this image is?
So this is of my body cam pointing towards the steering wheel of my Newark police cruiser.
All right, and how do you know it's your body cam?
It has my name right there
All
for
right.
Officer Ellis.
Thank you. And what is the date and time listed on there?
February 9th, March 9th, 2025.
Thank you.
You can see on that little monitor down at the bottom of the screen next to me. I know it's mine because it has
And
my
so
name
now,
on it.
can you tell me the location that you're at here in this image?
This is the 200 block of Clinton Street.
Okay.
Hey, come here! 384, you'll be out in front of 295 Clinton. Check 15's on Donald Hurley.
All right, so is the Hurley residence here?
Immediate to the left side, yes, sir.
Okay. And a moment ago, we heard you yell, "Hey, come here." What were you meaning by that?
I was attempting to tell Donald Hurley to step towards me.
Okay. Where had you seen Donald Hurley?
He was on the sidewalk right there.
Okay. Is that about where you're standing
Right,
now?
right in front of where I was standing, yes, sir.
Okay. And where did he go?
He immediately took a right turn into the porch and went inside the residence.
Is that through, is this a gate here on the left?
Yes, sir.
And he went through that? Okay.
Donald Hurley.
All right. And what were you doing in that point when you were going around the house?
I was making sure he didn't run out the back door.
Okay. And so were you looking over the fence?
Yes, sir.
Okay. And did you see him?
I did not know.
Okay. When you were alongside the house there, did you hear anything?
So when I walked to the north side of the residence, I heard a whole bunch of yelling and someone running up the staircase.
Okay. How were you able to identify that from outside?
It was right there next to the window, and I was right there.
The staircase was?
It sounded like a whole bunch of footsteps going up.
Got it. Okay. Did that sound like multiple voices yelling?
So it sounded like one individual yelling at other individuals.
Okay. And could you identify anything else about that one individual yelling at other individuals?
No.
Okay.
Go ahead, he ran inside.
All right. At this point, I'm going to skip forward a little bit, but can you give us a brief summary of what happened in the next few minutes?
So Donald ran inside. I was waiting for my backup, so that's why I was walking back and forth, just making sure he wouldn't run out the back door or the windows. But when I went towards the front door, that's when on my radio, another officer was in the backyard or in the back area, making sure he didn't run back there. So that's why I went back towards the front yard.
That is when you went to the back when the dog was barking?
Yes, sir.
And around that time was when you were informed that another officer was back there?
Yes, sir.
Okay. That's why you came to the front?
Yes, sir.
Okay.
Here.
Okay.
I need to go to my car.
I copy. 303. Stay out back, please.
Here.
Just stay here for a minute, all right?
I'm not leaving.
You're good.
I just got here.
Can you...
Who are these people?
I do not know who the woman in the red shirt is.
Okay. In your recollection, was she relevant to the investigation?
I don't believe so, no. Just send Donald out. We got no issues. But we are getting a search warrant.
So, at this point, you've said you've seen somebody who has a warrant out for their arrest. Why are you still standing outside the house and not going in?
So at this point, I'm just waiting for more officers to arrive on the scene.
Is that for your own concerns for your own safety?
Just officer safety, yes, sir.
Because currently the only other officer is on the other side of the house?
Yes, sir.
Okay. Also, at this point, did you have a copy of the warrant with you, the arrest warrant?
I did not have one with me. It was on my computer.
Okay, so you knew there was one.
Yes, sir.
It's just you didn't have it with you at this point.
Yes, sir.
Did somebody else later bring it?
They had it on their CAD unit. Yes, sir.
Okay. Can you describe what a CAD unit is?
Sorry, it's a computer inside the police cruiser. It has name, the felony warrant, and the address that the warrant is listed on. Ma'am, can we just get him out?
I just got here.
You're good.
I live in Akron.
You're good.
I came down to see my daughter. It's her birthday, so I just got here.
Yeah, she did. She ain't even lying.
Princess, down. Down.
Get him out.
I ain't really be laying here. What you talking about? I just came from downstairs. I didn't even see it. Here. Not at all. It's empty. I don't know what you're talking about. Lay down.
I believe he's going to be upstairs still. Donald, you're under arrest! It's the Newark Police Department!
You gotta catch me first!
Donald Hurley, you are under arrest! This is the Newark Police Department! Send Donald...
I had to get dressed, sorry.
If you could send Donald out, and we will leave.
He's not here.
I just want...
All right, we've just heard a new voice, I believe. Who is that voice?
So that's going to be Clarence Hurley.
Okay. And that's who you kind of identified as the defendant?
Yes, sir.
And what did you just say a moment ago?
I advised him that Donald Hurley was inside the house and he had a warrant.
Okay. And what did Clarence say in response?
He said he's not inside.
Okay. Now, you're at the front door?
Yes, sir.
There's another officer at the back door?
Yes, sir.
To your knowledge, was there any other way in or out of the house?
No, sir.
Had you been to this address on other occasions before this?
Yes, sir.
Okay. And had you been inside the house on other occasions before this?
I have not, no.
Okay. Is this, if I didn't ask already, is this house in Licking County, Ohio?
Yes, sir. Watched him go inside.
You did?
I watched him go inside. It's all. Get him outside. We are getting everyone here.
All right. And what did you just say there?
I told him we're going to get everyone outside.
Right before that?
Yes.
Did you say something to him right before that?
Oh, I don't recall.
Back up a moment.
Got a short memory. I just watched him go inside.
If you could send Donald out, and we will leave.
He's not here.
I just watched him go inside.
You did?
I watched him go inside. It's all. Get him outside. We are.
All right.
Okay. I advised him that I saw Donald come inside, and for everyone else to come outside.
And did Clarence say anything in response?
He said, "All right."
Did he ask you a question?
He said, "I did."
Asking you?
If I saw him, yes.
So you
We're getting everyone here, and we're getting a search warrant this time. So send him out. He's going to jail today. He's either going to go to jail and I'm not trying to be rude, but we did this last time. We're getting a search warrant.
Just woke up?
He is going to jail. Go inside and go get Donald. He is going to jail. This Officer Ellis, Newark Police Department, badge number 3339. Wanted felon is inside the residence. He's under arrest. Send Donald out. If you could go get Donald, sir. He's upstairs.
All right.
I'm going to see if he what?
Were you planning on charging Clarence Hurley with anything?
At this time, no.
Okay. What was the job you were there to do?
To get the felon outside of the residence so we can bring him to jail.
Okay. And what's the easiest way to get somebody out of a house?
Just if they can have either whoever, just for them to come outside willingly without us having to go inside the residence. That's the easiest way.
Thank you.
Where's Ayden?
How do you know that?
You're good. He's upstairs hiding, ma'am.
He's not here. I don't know.
Go get him, please.
He is not here.
Okay.
And I'm going to record this because
ma'am, you were perfectly fine.
You guys have got me out of how many times?
Of course.
I can't afford to be got again.
You're good, ma'am.
For nothing.
You're good, ma'am.
For nothing.
I'm here for Donald, not here for anything else.
Well, I'm going to make sure I get this recorded.
You were okay.
It's all going to be on tape.
Again, I'm Officer Ellis with the Newark Police Department. If you have any other questions, okay? Send Donald out.
I know who you are.
Send Donald out.
Who is this?
This is Clarence's wife, Joanna Lynn Hurley.
Missy, welcome.
I don't have Donald.
Donald Hurley, you're under arrest! This is the Newark Police Department!
This is ridiculous.
He's wearing dark colored clothes right now. Hood up.
Stay here.
I'm gonna...
Just send Donald out so we don't have to get the SWAT team out here. Ma'am, I'm not trying to be rude.
I said
Go find him.
he is not here.
Okay. Can you go find him inside the house?
He's not here.
He just ran inside and he's hiding upstairs.
Go see if your dad is here.
Just go get him. He's going to jail. There's no point in you guys getting in trouble for this. Okay?
I'm not getting in trouble for this.
For harboring and aiding, abetting a known fugitive? Yes, you will get in trouble.
I'm not here.
Yes, sir.
He's not here.
He's here. Go get him.
Here.
All right. Who just came back to the door?
Clarence.
And what is he continuing to say?
He's still stating that Donald is not inside the residence.
I told you you could come in and look.
Go get him. I'm not going inside. We're not going inside without a search warrant.
Okay, whatever.
What do you got one now?
We will. We're just waiting for other units to get here.
Well, he probably...
He's...
Let's at the back then.
Nope.
And what did Clarence just say there?
He's still not inside.
Did he say anything else?
I couldn't hear what he said.
I'll back up a little bit.
You couldn't hear? It's
inside. We're not going inside without a search warrant.
Okay, whatever. What do you got one now?
We will. We're just waiting for other units to get here.
Well, he punched. He's slipped out the back then.
Nope, he's not. I had some. So Clarence said he must have slipped out the back door then.
Okay. And based on your experience thus far, was that possible?
It was not possible, no.
Okay.
No touchy the judge's collar. It's one of the rules.
All right. Now, had you spoken to Clarence Hurley prior to this date?
Yes, sir.
Okay. When was that?
It was a few days prior to this.
Objection, Your Honor. Can we approach?
Yes.
Sidebar. Defense lawyer wakes up to object. It's a huddle. Their noses are practically touching. One more reason to brush your teeth every morning. You might be face to face with a judge for prolonged seconds. No, sometimes we can hear this. Depends how loud their huddle is. But we believe there is a jury just off to the left of the screen here. We can't see them.
Okay. You ask your question again.
Okay. All right.
Did you
my
talk to him
question was,
previously?
Or it intended to be, Clarence Hurley. Had you spoken to Clarence Hurley prior to this day concerning Donald Hurley?
Yes, sir.
Okay. How long ago? When was that relative to this date?
It was a few days to a week prior to this incident.
Okay.
We're in Licking
And
County,
where did you
Ohio
speak
right now.
to Clarence?
Right in front of the residence off of Clinton Street.
Okay. And what did you speak to him about?
So Donald had ran inside the residence prior to this event. And by the time I arrived on scene, the officers were clearing, stating that Donald was no longer inside the residence. So I was talking to Clarence and Joanna about the incident, about Donald having a felony warrant.
I wonder what his warrant was
So,
for.
that prior date, you didn't see Donald on that day.
Correct.
But you did speak with Clarence and Joanna.
Correct.
And did you advise them of consequences if he was living in their house?
Yes, sir.
Okay. What did you tell them?
I stated the same thing, that Donald Hurley had a felony warrant, and if they were going to harbor Donald and they knew he was inside, then they would get in trouble.
Okay.
How are you going to prove they knew?
All right. Continuing with the video.
He's
Slipped out the back then.
Nope, he's not. I had someone back there.
Huh?
I had someone back there.
Well, I looked. I didn't see him up there.
Okay. Me either. They're giving us consent to go inside. I saw him go up there.
I gave him consent from the first time he stepped up here.
They've been yelling the entire time.
I'm not coming in there without a search.
Who's up back?
I said you could go in my house.
We don't go in one person at a time. So. Is this
Okay, so as I asked before, you're not going in yet at this point for officer safety?
Yes, sir.
Okay. I'm going to skip forward ahead again to your recollection. Is there anything else
No, sir.
that happens?
No, sir.
Okay.
That explains the black band. On
All
the
right,
badge.
so all right.
What's the front room? Wait, he was on the
Go ahead, give us 99.
No, sir, we were in here the last time.
That's fine. Hey, Donald, it's the police department. You guys step outside, boys. Can you step outside, ma'am? Donald, police department, make yourself known.
Who was that passing you in the gray shirt?
That was Clarence Hurley.
And you follow somebody else into the resident?
That was Officer Jackson.
Okay. All right. So as I'm fast forwarding here, we're seeing a number of images. What are you seeing these in the course of?
So this is my body cam footage of officers searching the residence for Donald.
Okay. About how long did all of you search the residence for?
It took several minutes for officers to search through the entire residence.
And how many officers were there approximately?
4 or 5 officers inside the residence, I believe.
Okay.
Why does it look like we keep seeing credits on the screen?
And at this point, had all the other persons that had made themselves known to you exited the residence?
Yes, sir.
All other non-officers?
Yes, sir.
All right. And so, where are we now?
We're back in front of the residence.
Okay. And are you? Why did you go back outside?
So we had done a primary search of the residence, and we did not locate Donald at this time.
Okay.
That must have been embarrassing.
Did you later go back in the house?
Yes, sir.
That was in the course of the same day?
Yes, sir.
Minutes later?
A few minutes later, yes, sir.
So the family couldn't find him either? Maybe they didn't know he was there. It seems pretty straightforward. He said, you can come look, but he's not here.
All right. And do you recall what room this is here?
This was one of the rooms. I do not recall whose room this was.
Bedroom?
Yes, sir.
Were there any adjoining spaces off of this room?
The closet.
Sounds like they're tearing open Christmas presents.
Donald Hurley, if you're out there, make yourself known!
Is this the closet you were referring to?
Yes, sir.
Okay. Where are you yelling into?
So I'm yelling into a very small crawl space attic opening or doorway.
Is that in the ceiling of the closet?
Yes, sir.
We're gassing! Newark Police!
378. You have the interior drone.
We're gassing? I think it was bluffing. You don't just throw tear gas because you can.
Puts me in a bad spot.
So, man, no chances.
When you yelled up into the crawl space there, did you hear any response?
I did not hear anything, no, sir.
So what did you do next?
We're gassy.
I knew I couldn't fit through the door space, so we were either going to gas it or send our interior drone up. But we couldn't have an interior drone, or we didn't have any gas at the point, so I had to take my vest off so I can get small to fit in a small hole.
Okay. And is your body camera fastened to your vest?
It is, which is why it's now pointing towards the ceiling.
Okay, so what we're seeing here is the body camera still attached to your vest, which is laying on the ground?
Yes, sir.
Okay, and at this point, were you crawling into the crawl space?
Here in a few minutes, yes, sir.
Go look at the ceiling cam.
Donald, if you're up there, make yourself known!
We're sending the dog. That usually works.
One head off to every other location.
Yes, sir.
Doesn't seem safe at all. Confronting a cornered suspect without your body armor.
Good, Brad?
guys are checking the basement, right?
You already checked the basement, right?
You said he hit the back.
Yeah, I got there pretty fast.
Rachel, which new doc drop?
No, you know how you got upstairs and downstairs? Something little like.
Coming down! All right.
Was that your voice we just heard?
Yes, sir.
What did you say?
I was telling a few seconds before this, I observed Donald in the attic, and I was telling the other officers that we were coming down.
Okay, I'll back up a little bit.
Sir, you can climb up there. I'll help you out.
He fit, might take your
Bring
vest
your
off.
foot straight down. I got you. I'll lead you right there.
Was that when you were saying something?
Yes, sir.
And what were you telling them?
I was telling the officers down here I was going to send Donald downstairs.
Okay. So where did you find him?
So Donald was in a makeshift cubby underneath the attic insulation. So if you're looking at the attic, it doesn't look like there's anything up there besides insulation. So I had to start pulling insulation up from the attic space, and he was tucked in a makeshift cubby.
You got him?
Donald must be tiny. He fit between the rafters?
Coming down! All right. As soon as you get down here, hands on your back, Donald. On your back.
I imagine it's hot up there, too.
Sure it was last time, then. Yep.
That's where he was last time.
Yeah, you're good. Come on down. Here, let me catch you.
That's where he was last time.
All right, who's this man that we see here?
That is the wanted felon, Donald Hurley.
All right. And is it the same person in the same outfit that you'd seen?
Yes, sir.
Outside the house before?
Yes, sir.
Okay. Everything we've seen thus far on the body cam footage, is that a fair and accurate representation of the events as you recall them?
Yes, sir.
And is the document in front of you marked Exhibit 2, is that a fair and accurate copy of the warrant as you dealt with that day?
Yes, sir.
Nothing further.
Mr. Keese? Thank you, Your Honor. Morning, Officer Ellis.
Sir?
Well, let's start with the previous time you were talking about. So you
defense.
participated, I think you said, albeit a little bit late. Officers had searched the house previously and did not see Donald Hurley, correct?
Correct.
Okay. So this time you testified that you saw Donald Hurley outside, and it was approximately 1 minute into the video, and you got out of your vehicle?
I believe so, yes, sir.
Okay. And immediately afterwards, you go to check the back fence, or the back area, correct?
Yes, sir.
Okay. Now, after that, you had went up to the front door, and at that point, you began speaking with Mrs. Hurley, correct?
Yes, sir.
Okay. But actually, before that, you had testified you heard voices from inside. Let me ask you this. Is it accurate to say there were approximately 5 or 6 individuals inside the house at that point?
Yes, sir.
Okay, and you couldn't hear what was being said or who was saying anything, correct?
Correct.
I'll just sit next to you a second.
For purposes of the record, we're starting at 2 minutes and 48 seconds.
Knock on my door.
Get out of here. Can you send him out, please?
Sorry, who?
Can you send Donald out, please?
I just got here. I don't even know if he's here. I haven't seen him.
I copy. He looked at me and ran inside. So I believe he's upstairs right now. We have the place surrounded, so he's not going anywhere.
Yeah, I just got here.
Okay.
I need to go to my car real quick, baby.
Hi, copy. 303. Just stay out back, please.
Where?
Just stay here for a minute, all right?
I'm not leaving.
You're good, you're good.
I just got here.
Can you send Donald out, please?
What? No, you testified that this person who stated they did not see him, you did not charge and didn't believe that they in fact knew Mr. Hurley was there, that Donald Hurley was there?
I did not know this individual's name, nor could I get it.
But you didn't charge her either.
Fast forward to 4 minutes and 6.
Two, you can come in.
So at this point, you begin speaking with Miss Hurley, correct?
Yes, sir.
I'm not going in right now. Nope, not without a search warrant, because if he comes out here, that I'll just take him to jail. I'm not going inside without a search warrant, because if I go in there...
Now, you were granted access to the home at this point, correct?
Yes, sir.
Okay. But for your safety, you said you either wanted a warrant or backup officers, correct?
Yes, sir.
Okay. But approximately 3 minutes after you exited your vehicle, including the 1 minute for checking in the back, you were granted access to the home.
Yes, sir.
Okay. And the waiting for backup gave Donald Hurley more time to possibly find a hiding spot or go up in the attic, correct?
Correct.
Wallflower, thank you very much. 29 months. Summer is busy on the farm. What are your thoughts? Did the parents know he was there?
To 6 minutes.
Send Donald out, and we will leave.
Not here.
I just...
So at this point, you speak with Mr. Clarence Hurley for the first time, correct?
Yes, sir.
Okay. And stated that Donald Hurley is not there.
Clarence stated he was not there.
Correct. Yeah.
Correct.
Okay. And Mr. Savage asked you earlier about a statement Mr. Hurley had made, Clarence Hurley, that he had just looked and Donald was not there, correct?
Correct.
Okay. And stated that if he was here, he must have snuck out the back door.
Correct.
Okay. Now, if you did not know he was there, you tell him Donald Hurley is there. If he doesn't find him after looking, that's the only reasonable conclusion, correct?
Correct.
And you didn't find him after looking either.
And so Mr. Hurley tried to find himself after you received backup. You and your team went through the house, I think you said approximately 10 or 15 minutes. And on the first week through, you guys didn't find him either, correct?
Correct.
Okay. On the second pass through is when you go to this closet and see that there is an opening to the attic, right?
Correct.
And you said it was just an opening, no trap door or anything like that?
It was closed.
It had like a piece of drywall over it?
On top of it, yes, sir.
Okay. There's nothing indicated that additional assistance or another person would be required to go up there. Donald Hurley could move the drywall, place it back, and then put the insulation over himself, correct?
Correct.
You were granted permission, you testified you were granted permission by Mrs. Hurley to enter. Mr. Hurley also granted you permission, correct?
I believe so, yes.
No further questions.
Yeah. Case dismissed.
Sir, Mr. Savage.
The individual that you testified was not charged with any other any obstruction of justice crime. Had you had any prior interactions with that person?
I have not, no.
Of any kind?
Nope.
And specifically no interactions regarding the legal consequences of Donald Hurley living in that residence?
I've never seen her or talked to her before.
Okay. And to your knowledge, did that person live at that residence?
I do not recall.
Okay. And the closet that he went up to that you testified, there was a question about whether Donald could have gotten up into there all on his own. Were there other objects down below?
Yes.
Okay. Would Donald have had to step up onto something to get up there?
Correct.
Okay. Did it appear as though any items had been moved by somebody other than him?
So I could not step up without having to either move a chair or something in order for me to get up into the attic space.
So could it be that somebody else that was not up there had moved items?
Correct. They moved items and then closed the door and locked it behind them.
Hang on. Closed the door and locked it? Can you lock it from the outside?
Did you have any further conversations with Clarence Hurley after what we've seen thus far?
After we were walking out with Donald, correct? Is that what you're asking, sir?
Yes, yeah.
I believe it was just...
Objection, Your Honor. This is outside of Cross.
Mr. Savage.
Outside the scope of Cross.
Withdraw. Nothing further.
Mr. Keys.
Thank you, Your Honor. Briefly, you indicated you didn't see anything. First, this desperate man calls for desperate measures, correct?
Correct.
Okay. And secondly, not to insult Mr. Hurley here, but is it apparent to you that he has some pretty significant health issues?
Looks like he has a breathing
Objection,
tube.
relevance.
The point is that he's saying someone had to run up the stairs, help him run back down, and during that time would have known about it and was lying. Is Mr. Hurley in the condition that he would have been able to run upstairs, come down, lie to you without being out of breath or anything like that? In his physical condition, does that seem possible?
Here goes the whole case. Boom. That's the end of the case. It's not even possible. The state's witness just said...
Sir?
The state's witness just said it's not possible for the defendant to have done what we were charging him with.
No further witnesses at this time. I'd like to move for admission of Exhibits 1 and 2.
Objection to the exhibits.
Here's this one.
Just to make sure it's not part of
No.
Just subject to that, no objection.
Yeah, just 1 and 2.
You want to approach?
Oh, sorry.
Okay, we might get a judgment of acquittal here.
Okay, marking that.
Gotcha.
So it's not part of it.
Yeah. So no objection.
We may get a judgment of acquittal.
The warrant. Yes.
The one observing witness.
Nothing needed in the video is inadmissible. Sorry.
From the seconds I replayed.
Okay. Did we solve that issue?
Sorry?
Did we take care of that?
Yes, I
All right, thank you.
pointed out that
Okay.
information. Yeah.
Mr. Keys?
This defense has no witnesses, Your Honor.
Okay. All right.
Defense rests.
I guess we'll take a short recess to prepare for closing. And I'll get your instructions.
All right.
Yes.
Yeah, okay. Okay. Did not discuss the case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. Let's take a recess. Once the attorneys and I go over the jury instructions, we'll reconvene for closing and instructions.
As long as Ohio has a JOA option. We'll wait for just a second to see if they come back. I don't know how this can go to trial. If the one witness, the only testimony that exists that the juries are to consider, says it's impossible for the defendant to have done what they're charging him with. How? First of all, the jury cannot convict, right? Now there's probably backstory here. There's probably clearly he hid there again. He hid in the same place. This defendant's son hid in the exact same place where they found him last time when they were looking for him. Okay, so this is repeating history. So there's probably something back there, and obviously there was a conversation afterwards that probably would have been more evidence to say that there was something he did to stall the police or something and allow him to hide. It probably is there, but it wasn't presented to the jury. And now we're stuck waiting. We'll keep the audio on here. While we wait, let's see if we can go check out Judge Wolf, who happens to be back in the Heavenly Wood courtroom. I haven't seen him in dog's age. It's been a long time.
I have signed your final order and changed your name, so you can get a copy of it a little later in the day from the clerk's office, all right?
Thank you so much.
You're welcome.
Somebody just got a name change. I wonder if that's after a divorce? Guessing. We've got audio still on from
Good morning. If you'll raise your right hand,
we're not going to miss a
place
minute.
under oath.
Yes.
This courtroom
Are you
is
Veronica
amazing.
Barreto Duke?
Yes.
Ms. Duke, you are here today on a request to change your name. I'm required to ask you a few questions. Are you asking to change your name to avoid criminal prosecution?
No.
Are you asking to change your name to avoid your just debts or obligations?
No.
So you're just changing, you just want to drop the last surname of Duke, is that correct?
Yes, sir.
And be known as Veronica Barreto?
Yes, sir.
And who are you, sir?
My husband.
Pardon?
I'm her husband.
Okay.
What's
so
your
you're
name?
here for moral support?
Yeah, pretty much.
I'm Mr.
Well,
Duke.
normally they would tase you as you came down the hall, down the aisle when you're not connected with the case, but apparently they knew you were a good fellow, so they didn't do that. Have you have an order changing your name?
Yes, sir.
Maybe she's just not a fan of Duke University. Guess you can't change your name to avoid criminal prosecution or to avoid collection of just debts.
I'm drawing a line for you to sign off on that. The reason I do that is just to make sure that there's never any question about the fact that you were here and you actually wanted your name changed. Believe it or not, there might be a few divorce situations where the wife didn't want her name changed and the husband shows up and wants to have his wife's name changed. So I always want to have the person having their name changed sign the order to acknowledge that they are consenting to this.
Kickity's Garden,
Right.
25
I am granting your
months.
name change request, and you can get a copy of it a little later in the morning from the clerk.
Yes, sir. Thank you.
Now you get to get all new credit cards, all new driver's license, a new social security card, and everything else that goes with it. Insurance, you name it. The fun work has just begun. You get your name changed. Kikity, good to see you here. Hope you're doing well. Trent, this is my vacation week. So I'm not sure if we're going to get a really... hang on. Look at this stellar white suit. Dude just waltzes down like he
I've
just came off
prepared
the
an order
cricket
for you, Your
pitch. Dressed in white.
Thank you.
Also wore it to his wedding. That's a surprise raccoon in the recycling bin. Hopefully it was able to
Jean
get out.
Shepherd or Bethany Shepherd? This is a breach of contract action, correct?
Correct, Your Honor.
All right, your motion for default is granted.
Thank you, Your Honor. May I be excused?
You may.
Thank you.
Default judgment because nobody else showed up. Judge is flying through the docket here. I love this courtroom. I love just the layout, all the light color wood.
Your
I'm
Honor,
not sure what it is.
Here on behalf of Petitioner
Kind of,
Robbie Lawson on a motion for default, I don't believe there's any opposition this morning.
Right. With service by publication, the time for answer has expired, and you're entitled to a judgment by default.
Thank you, Your Honor. I'll subsequently submit an order.
Thank you.
Thank you.
Some people even have to get new email addresses after changing their last name.
Mr. Atchison?
Morning, Judge.
Good morning. Are you proceeding on you need your witnesses up?
I do. I have them here, Judge, and yeah, I'll bring them up.
Everyone who's going to testify, raise your right hand and be placed under oath, please.
I love these group swear-ins.
Yes.
And Your Honor, we're here this morning on a motion for default as it relates to the petition for divorce filed by Ms. Wren against Mr. John Wren. Your Honor, service of process was accomplished in this matter. He was served with the petition for divorce. The 30 days has passed. He's filed no answer. And here he is.
And here he is.
All right, let me deal with this situation. Are you John Allen Wren?
Sir.
Mr. Wren, you were served with a summons for divorce that basically was served on you on September the 23rd, on May 14th of 2025. That summons say the following: you are summoned to defend a civil action filed against you in Chancery Court in Dixon County, Tennessee. Your defense must be made within 30 days from the date of this summons is served upon you. You must file your defense with the clerk of the court and send a copy to the plaintiff's attorney at the address listed below. If you fail to defend this action by the above date, judgment by default can be rendered against you for the relief sought in the complaint. And the file does not show that you filed any sort of answer or response, correct?
No. I had a lawyer that didn't file my response. I hired a new lawyer. Go back today and talk to the lawyer.
My lawyer didn't file a response?
And I've called his office about 3 or 4 times. No one's answered or returned my call. They've answered and returned my call.
Well, he's your wife's lawyer. He's not your lawyer. I understand. Just listen to me. And so as a result of that, he's not obligated to talk to you. However, I will pass this case on the docket, Mr. Atchison, and let you talk to him. What I want you to understand is that because you've not filed an answer, then she's entitled to a default judgment on the grounds of divorce. Then I would have to have a hearing to determine whether or not, what should be done about the divorce, the property that was incurred during the marriage, the debts, and so forth. And that part you can talk with Mr. Atchison if you choose to.
I did that. I tried to do that. The person didn't do it, so I fired him.
I'm sorry?
I tried to do that with a lawyer and they didn't file it. Reasons didn't file it.
Okay. Well, I understand that, and the only thing I can tell you is that because you've not filed an answer, even pro se, you can file your own answer. But because you haven't done that, then you haven't actually appeared, even though you're physically here, under the rules of procedure.
Whoa.
Now, I'm trying to give you now you be quiet when I'm talking. Mr. Atchison, you put on your proof. You can have a seat, Mr. Wren, or you can stand there and behave yourself. If you don't behave yourself, I'm going to have the bailiff escort you from the courtroom. Do you understand that?
If you would, state your name for the court, please.
Jessica Wren.
Now, Ms. Wren.
Don't talk to the witnesses. Mr. Wren, don't talk to the witnesses. You step right up. I don't care. You step right over there to the side.
Come over here and sit down.
Bailiff steps in and says, I'm going to manage this.
Go ahead.
The reason we're here today is you filed a petition for divorce, correct?
Yes.
Within that petition, we established the grounds for this divorce. Is that correct?
Yes.
The grounds that's been established is irreconcilable differences. The fact that that your husband, Mr. Wren, has been charged with felony drug offenses in this county, correct?
Yes.
And that occurred during the course of the marriage, correct?
Yes.
Raise your right. I thought we had placed everybody on.
I thought we did too, Judge.
We did.
We had.
Yes.
And based on the grounds for this divorce,
you can't get a divorce on irreconcilable differences because it can only be granted on irreconcilable differences if, in fact, there's an agreement between these parties reduced to writing in a marital dissolution agreement. But she has alleged that the husband is guilty of abusing narcotic or other illegal drugs during the marriage, and she also alleges that he is guilty of inappropriate marital conduct, and she alleges that he has offered such indignities to her person as to render her position intolerable, all of which are statutory grounds. So you need to proceed on those 3 grounds
Correct.
for your evidence rather than irreconcilable differences.
everybody back.
Yes, sir. All
And Ms. Wren, based on those grounds, you wish to move forward with this matter, correct?
Which one do we want? We've got two.
Now,
Before we bring the jury back.
It looks fantastic, Ron.
Okay, did you look at the jury instructions?
Yep. How long has Mr. Wren been away from the marriage and the marital residence?
Look at
Fully since May.
real quick.
Of this year.
We've got both courts. Which one do we
Now-
want? Which one do you want?
Have you
What,
been
Tennessee?
maintaining the payments on the marital residence?
Yes.
The general upkeep?
Yes.
The marital residence?
I've got them both recorded, so we can catch. Which one do you want to watch right now?
And has,
Both. We want both.
has personal property been divided in this matter?
Let's go with divorce. Okay.
Okay, Mr. Wren still has property at the residence?
Yes.
Now, do you guys have
I'm
any
recording the
joint
other
marital debt
No.
other than the residence?
Other than the residence, no.
And how long have you guys been married?
23 years.
Oh, man.
Now, was the home purchased during the course of the marriage?
Yes.
And you're aware that Mr. Wren currently has criminal charges pending in this county, correct?
Yes, I do.
And what do those charges relate to?
Drugs and a weapons charge.
He might be tweaking now.
Now, do you guys
He's quite
have,
agitated.
are the bank accounts separate?
Yes.
There's no minor children
No.
currently in this marriage?
No.
Your children are grown, correct?
Grown.
And based on the filings in this matter, you wish to move forward with this default?
I do.
Now, we have your mother and your daughter present, correct?
Yes.
Judge, if I could, just ask them some questions.
Step up to the microphone, please.
Would you state your name for the court?
Vicky Parker.
And Ms. Parker, are you the mother of Ms. Wren?
I am.
Ms. Parker, you've heard your daughter's testimony, correct?
Correct.
Now, were you present or have you witnessed the grounds that were set forth as it relates to Mr. Wren's abusing narcotics, illegal drug use during the course of the marriage?
Yes.
And
were you also present for the inappropriate marital conduct
Look at
that's
the
taken
judge's
place?
pencil. It's a
I have.
mini gavel.
Has there been
The erasers
prior
on both
instances of domestic incidents involving Mr. Wren and Ms. Wren?
Yes.
Have there been prior domestic incidents involving Mr. Wren and his children?
Yes.
Yeah, this is going to be granted.
That's all the questions I have for that witness, Your Honor.
Any reason we have to put this young lady in this situation?
No, Judge. I don't see any reason to.
Corroborating witnesses, in my opinion, I don't think it's, obviously, this is an emotional situation for her, and I'm not inclined to require her to
And
testify.
I would submit the same.
But if you will step back, ma'am, let me ask these questions. The testimony that I've heard is that there's a marital residence with the debt that she's been paying, but is there any equity in that property?
Judge, there is equity and there is still currently a mortgage. There's about $80,000 that remains on the marital residence that Ms. Wren has been paying and keeping up.
Well, as you know, I'm required, even in a default situation, to make an equitable or fair division. So Mr. Wren needs to be treated fairly regarding that marital property. What are you proposing?
Judge, it would be my position, just like if this matter would have moved forward in a different manner. It was Ms. Wren's understanding as well that the marital residence would be listed and sold, and then the proceeds from that sale would be split between her and Mr. Wren based on the length of the marriage and the fact that it was purchased during the marriage.
All right. Then What about she said, I believe if I understood her correctly, the personal property had not been divided as well.
It has not, Judge. It's my understanding that Mr. Wren still has personal property at the residence. However, there is a matter of Mr. Wren is self-employed, does own his own business. Ms. Wren does not want any part.
What's the name of the business?
W&W Construction.
W&W Construction.
All right. Then anything else of course, you said there's no joint debts between them other than the mortgage.
Correct.
All right, I'm going to order, number one, she is awarded a divorce on the grounds of inappropriate marital conduct, and the default judgment is granted based on the fact that no answer was filed. Secondly, I'm going to order that each of them pay any debts that are incurred in their own name. I order that the marital residence will be listed for sale with a reputable realtor at the price that's recommended by the realtor.
Wow. Realtor gets to set
both
the
parties
price.
will cooperate in signing any listing agreement that might be done. If Mr. Wren for any reason refuses to do that, then I don't know why he would, but if he were to refuse to do that, then under those circumstances, it will be her authority by this court order to sign the listing agreement solely. Once the property has been sold and the closing takes place, the proceeds will be paid into the registry of the court for a division, and at that point in time, both parties will be entitled to a hearing to determine how that should be done. Normally, it would be a 50-50 division, but if she's been making the mortgage payments for some time, then we'll go from there. The second thing is his personal property, and that includes his personal possessions and any work-related items that he may have are going to be he's entitled to recover that, but he's going to have a civil standby to go and pick those items up. As soon as that can be arranged by him, he can do that. So, of course, the costs are taxed to Mr. Wren.
He wants to talk.
And we go from there. Mr. Wren, let me tell you something.
I mean, I don't have a lawyer, so I can't say nothing.
What?
I don't have a lawyer here, so I can't say nothing.
Oh, sir, you haven't filed an answer to
contest. My house in 23 and a half years.
You have not filed an answer to contest this divorce action, and as a result of that, you've had more than 30 days to file an answer. You haven't done it.
She didn't do what she's supposed to.
And you are teetering on the edge of going to jail for 10 days.
I'm getting everything. I paid every payment for 2 damn months. You're saying she's paid all these payments. I've got every receipt. She's paid nothing except for
When this house gets sold, then you will have the opportunity to have that done. You'll have the opportunity at a hearing to show what you've paid and ask for any kind of reimbursement for that. Now, you open your mouth again, I'm going to put you in jail for 10 days. That's the judgment of the court. He needs to leave the courtroom. Leave the courtroom.
I've never seen him.
Stay in the courtroom until he has exited the courthouse, and then one of the officers will escort you to your vehicle.
And Judge, just for clarification, would that entitle Ms. Wren to exclusive possession of the residence until this matter is?
Yes. The only provision is that he would be entitled to have
Still
opportunity to recover his items of property. So.
And Judge, I would ask that, based on the default, Ms. Wren is asking to be returned to her maiden name, and I will put that in the order as well.
That is granted as well.
Thank you, Judge.
Well done.
I get him. Yeah.
Yeah, if he comes back in, we've got problems.
Thank you.
Call the next case.
It's sad what you can lose from a drug addiction. And clearly,
Judge, this is just a motion for publication. I represent the petitioners, and we've done an affidavit that set forth that the birth mother or the only respondent's whereabouts have been unknown for some time. The question I have is if your honor's inclined to grant it, where we publish. And as we stated in our affidavit, in July of 2024, she was in Kingston Springs in the DCS case. As recent as April of 2025, she was in Kingston Springs in Humphreys County on a citation. There has been rumor, and there has been social media, that she could be in Mississippi. I don't find that as
Could
reliable.
be in Mississippi?
Could be. But it's like social media
MISSIS,
post,
yeah.
it's a rumor of a family member, nothing as strong as there's a court order in criminal conduct in Kingston Springs, Tennessee. So we're asking a guest to publish in the Kingston Springs, Tennessee area because that's the last known recorded address with a court. We put everything in the affidavit because we wanted to be frank with the court about what we found everywhere, but I just don't know how reliable the social media post could be as to her current whereabouts. It is a TPR. We do need to get her notice in the best way possible. So that's where we are, is if you're inclined to publish, where we publish.
So this Facebook posting in Mississippi Missing Persons Alert saying that she's been missing for over 2 weeks and is 5 months pregnant, there's no other information that you have about that?
No, sir, and when we go back to click on that now, it's gone. So it's like it was there, and then it's been taken down. So I don't know how reliable that is or is not. Twitter says she may live there. When we check VineLink, even as recent as this morning, she is not incarcerated in Tennessee or Mississippi. So.
All right, well, your affidavit of reasonable efforts, I think, has been met, so I will grant your request for a motion by publication.
Okay, and do you feel
Service
that?
by publication.
We're about
Okay,
ready
you
to
feel
jump
Kingston
to Ohio.
Springs is the appropriate place to publish with the last known
I
court
think so.
recorded?
Do we have to use two now?
We do. It's if there's a secondary publication, we're supposed to find it at a website, but I don't know if Humphreys County has one.
Dixon Post is the one that's usually used here.
Okay.
So if you got the Dixon Post and what is the Kingston Springs paper?
Yes, sir, I think so.
What's
I
the
think
name of it?
It's, well, I don't know what the name of it, I hadn't prepared the order because of this new law.
All right.
We're supposed to, if there's a secondary source online free for somebody, supposed to do it if there is one, but I don't know if every county has one. Okay, all right, we'll contact the Dixon Post and follow whatever what they.
All right.
That or Humphreys County, so.
3,
Whatever service both.
2, 1. It's
Thank you,
always
Judge.
great to visit Tennessee. Judge Wolf, we're going to bail on this one before your next case. Going back, the jury's coming in right now. And we're going to hear how this goes. I think we're going to get jury instructions as well. It should be pretty brief. One witness, one charge. Well, it would help if we have audio. Let me give you that. Sound, HDMI. There we go.
Okay, come on back in and have a seat.
You can switch.
You're welcome.
You can switch. Audio sounds tinny on this. See if I can skip ahead a little bit. We can skip some of the instructions, I think.
There's
Go straight to the closings. There we go.
He's not here. He's not here. He's not here. He must have slipped out the back. So these are the statements that you all heard Clarence Hurley make in response to Officer Ellis's repeated requests for Donald Hurley to come out, or if not that, then for the residents of the house to ask him to come out. Now, so those are the defendant's statements. The other testimony we have from Officer Ellis is that this was not the first time they had discussed this very matter of Donald Hurley, who was being searched for. You will see on the warrant, which you'll be provided with during deliberations, that warrant is dated 2024, September 9th. So they've been searching for Donald Hurley for some time, and as Officer Ellis told you, about a week before, Officer Ellis had had a personal interaction with Clarence Hurley as well as his wife, informing them of the legal consequences of their actions if Donald Hurley was found living in their residence. Now, on that first occasion, Donald Hurley was not found living in their residence, but On this one, he was, as you all saw. And I would encourage you to listen closely to the jury instructions, specifically the definition of harbor. Now, harbor again falls under the charge that on March 9th, 2025, in the city of Newark, Licking County, Ohio, the defendant Clarence Hurley did unlawfully, with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another for crime, did harbor or conceal such other person. And the definition of harbor, which the judge will give you, is to harbor is to provide lodging, shelter, or refuge to another person. And we all saw Donald Hurley on that camera being let out of the attic, and Officer Ellis informed you of all the events that led up to that, and you can all see those events as well. So, the nature of obstruction of justice is that no one in these charges acts alone. The essence of it is somebody helping another to evade justice. Nor, in this instance, is Clarence Hurley alleged to have acted alone. There were clearly other people there, and it is a complex situation of exactly who did what, but nonetheless, we have those statements from Clarence, and we have testimony from Officer Ellis and his body cam footage, letting us all know that they were aware of the consequences of their actions, and nonetheless stuck to their story of he's not here. He's not here. He must have snuck out the back. Thank you.
That's the end of the prosecution closing.
Thank you everyone for paying close attention. Luckily this was probably one of the shortest trials I've ever had, so it was pretty brief. As I said at the beginning of this, I didn't expect too much would actually be in contention here. Previous week, as Mr. Savage just stated, police did search the house, attempting to find Donald Hurley there. At that point in time, Mr. Clarence Hurley and his wife had said, no, he's not here, and in fact, Donald was not there. This day, Officer Ellis did see Donald Hurley. He ran into the house and was later found in the attic. The state is asking you to take those facts, the uncontested ones, and go, well, he was there, so obviously he was lying that he was actually there. What the state didn't show, and what the evidence contradicted, was that Mr. Clarence Hurley knew he was there and was lying with the purpose to hinder the discovery apprehension of Donald Hurley. So what was in opposition to knowing that they were there? Well, as soon as Officer Ellis got out, he checked the back, fair enough to want to make sure Donald didn't run away. Comes up, as soon as Joanna Hurley, the other household owner of Mr. Clarence Hurley, opened the door, Officer Ellis stated, Donald Hurley's in there, he has a warrant, tell him to come out. Immediately, as he testified, was granted access to the residence to come in and search for him. That is not consistent with trying to hide someone. And again, this was extremely shortly after Donald Hurley ran inside the residence, where there were, as testified, 5 or 6 other people. Officer Ellis didn't want to do that, fear for officer safety, possibly a warrant. Fair enough. During that time, however, it gave Donald Hurley sufficient time to get up into the attic, hide himself, and later be found. Most importantly was the interaction with Mr. Clarence Hurley. As soon as he comes to the door, again, Officer Ellis is granted permission to come and search. Now, Mr. Savage is making a big ado about, oh, he must have run out. Well, as Officer Ellis testified, if Mr. Hurley didn't know Donald was there, he has an officer telling him, I saw him come in, the only reasonable conclusion is, well, I guess he ran outside because I don't see him and I searched the house for him. Not only did Mr. Hurley search the house for him, Officer Ellis testified he and a team of other officers searched the house for 10 or 15 minutes and still didn't find him on that first go-through. Again, it is apparent that Mr. Hurley was being honest. You can come in. I searched for him, he didn't see here. Well, if you're saying he's here, then the only thing is he must have run out the back door because I didn't see him. And then finally, Mr. Savage was trying to make this awful. Someone had to help him into the attic. Whether he can climb up there on his own, I can't say for sure. But with respect to Mr. Hurley, Officer Ellis said, well, if someone were to help him, they would have had to move stuff, come downstairs, upstairs, yada yada. When expressly asked that final question, with Mr. Hurley's physical condition, is it possible for him to go upstairs, come back downstairs, talk to him, and those short, brief moments of when Mr. Ellis saw Donald Hurley and was conversing with Mr. Hurley? And he, in no undoubted terms, said no, it was not possible. And so I'm asking you to consider the totality of the circumstances and evidence that was put on here today. It's not just, was Donald Hurley there? Did they find him? Yes, Clarence Hurley's guilty. What we have to find is that he knew he was there, and he had the purpose to hinder the discovery and apprehension of Donald Hurley. All of the actions point otherwise. And it's for that reason I'm going to ask you to find Mr. Clarence Hurley not guilty. Thank you.
Says the state gets another go at it.
All right, so briefly, the defense is asking for you to believe that Clarence Hurley did not know that his son was in his own house. The officer has testified that he was there, was believed to be there on multiple occasions. They couldn't prove he was there on the first occasion. And with regards to that, I think that informs the Hurley's actions in later coming forward and being as willing as they were to let officers into their home. The officers had searched the house previously and weren't able to find Donald. On this day, they searched for Donald and almost didn't find him until they went back in and checked again. So I think that is worth some weight when considering their actions and how they went about offering the police entry into their home for the reason that they expected it to go as it had before, where the police would search the home and wouldn't find Donald. So with all that in mind, I would ask that all of you follow the reasonable conclusion here that everyone in that house was aware of the other people that were in that house. And specifically, Clarence Hurley is one of those people, as testified by the officer and from what you saw in the body cam footage, which you can go back and review it as you wish. And that I would ask you to make a finding of guilty on one charge of obstruction of justice. Thank you.
In Ohio, you can file a judgment of acquittal.
Members of the jury, you have heard the evidence and the arguments of counsel. The court and jury have separate functions. The jury decides disputed facts, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law or to apply your own idea of what you think the law should be. The case before you began with the filing of a complaint. The complaint informs the defendant that he has been charged with a crime. You may not consider the fact that it was filed for any purpose. A plea of not guilty is a denial of the charge and puts at issue all the essential elements charged in the complaint. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces testimony or evidence that convinces you beyond a reasonable doubt of every essential element charged in the complaint. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending upon moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any facts the court requires you to accept as true. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all the elements of the charged offense beyond a reasonable doubt. Direct evidence is the testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes exhibits admitted into evidence during the trial and stipulations that you were instructed to accept as fact. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically follow according to the common experience of people. To infer or to make an inference is to reach a reasonable conclusion of fact that you may but are not required to make from other facts that you find have been established by direct evidence. Whether an inference is made rests entirely with you. The evidence does not include any statement made by counsel during trial unless such statement was an admission or agreement of certain facts. The opening statements and closing arguments are not evidence. They are designed to assist you in evaluating the evidence. The evidence does not include any statements that were stricken by the court or that you were instructed to disregard. You must not speculate why an objection was sustained to any question or what the answer to that question might have been, because these are questions of law and rest solely with the court. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You will use the test of truthfulness that you use in your daily lives. These tests include the appearance of the witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, and the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness testimony such weight as you think proper. You're not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of the witness. It is your duty to decide what testimony to believe, what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Two exhibits have been admitted into evidence and the testimony relating to them. You will decide what weight, if any, the exhibit should be given in light of all the evidence. You will have in the jury room the verdict forms and all the exhibits received into evidence during the course of the trial. You will not be given any other exhibits during your deliberations. It is not necessary that the defendant take the witness stand in his defense. He has a constitutional right not to testify. You must not consider the fact that he did not testify for any purpose. The defendant is charged with obstructing justice. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 9th day of March 2025 and in Licking County, Ohio, the defendant, with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another for a crime, harbored or concealed that other person. A person acts purposely when it is the person's specific intention to cause a certain result, but when the gist of the offense is a prohibition against conduct of a certain nature, regardless of what the offender intends to accomplish thereby, it is the offender's specific intention to engage in conduct of that nature. To harbor is to provide lodging, shelter, or refuge to a person. The state is not required to prove that the other person aided by the defendant was apprehended for, charged with, convicted of, or pleaded guilty to the crime that the other person committed. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of obstructing justice, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any of the elements of obstructing justice, your verdict must be not guilty. I left the forms in my office. They're on my desk. You will have with you in the jury room two verdict forms, one for guilty, one for not guilty. When you have reached a verdict, you will complete the form that corresponds to your decision and sign the verdict form in ink. The court has instructed you in all the law necessary for your deliberations. I will now instruct you in how to conduct your deliberations and prepare the verdict forms. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide the disputed questions of fact, to apply the instructions of law to your findings, and to render your verdict accordingly. Your duty as jurors is to arrive at a just verdict. Consider all of the evidence and make your finding with intelligence and impartiality, and without bias, sympathy, or prejudice, so the state of Ohio and the defendant will feel their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view of the facts, you are instructed to disregard it. It may be difficult to remember all the instructions I have given you, so you will be provided a copy of these instructions to consult. If you have any questions, the foreman must put your question in writing, indicating specifically what is requested. You may deliver such communication to the bailiff. Where a term has not been defined for you, you must give that term its common and ordinary meaning. You may not discuss or consider the subject of punishment. Your duty is confined to deciding the guilt or innocence of the defendant. In the event that you make a finding of guilty, the duty to decide punishment is placed by law upon this court. Your initial conduct upon commencing deliberations is important. It is not wise to express immediately a determination or to insist upon a certain verdict. Having so expressed yourself, your sense of pride may be aroused, and you may hesitate to give up your position even if shown that it is not correct. Consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with other jurors. Do not hesitate to change an opinion if convinced that it is wrong. You should not surrender your considered opinion concerning the weight of the evidence, however, in order to be congenial or to reach a verdict solely because of the opinion of other jurors. When you go into the jury room, your first function will be to select one of your number to serve as a foreman. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than the others. The foreman serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty the foreman has is to make sure that the verdict forms are filled out properly and that the exhibits are returned to the courtroom. If you have a question, it should be discussed in the privacy of the jury room. It should be reduced to writing so that there will be no misunderstanding as to what is requested. It should not reflect the status of your deliberations. It should then be delivered to the bailiff, who will submit it to the court. Members of the jury, this is a criminal case, and in a criminal case, it is necessary that you have a unanimous verdict. That means all 8 of you must agree in order to bring a verdict back to this courtroom. When you retire, you will have the verdict forms that I have just gone over. I will place in your possession the verdict forms and the exhibits. At this point, I will want to thank and excuse our alternate juror, Ms. Gump. You're free to go. You're welcome to stay until a verdict is reached, whichever you like. You're instructed you're not allowed to tell anyone what your verdict would have been until the whole jury has announced its verdict in open court.
There we go. Ms. Gump, you out of here. Start the deliberation.
At this time, the jury may retire and begin deliberating.
So as they pause, we switch to live. Holy cow, that, you hear that? That's what I hear all the time with my tinnitus, but give me just a second. Let me fix the audio here. I've got to leave it on so I can tune it out. There we go. All done. All right. They're now deliberating. They've been deliberating for 11 minutes. We're back live, so if something happens, bonus tinnitus for sure. Let's see. Yes, the Shelby Neely case did conclude last week. If you missed it, it was right at the end of the day on Friday. It came in almost perfect timing for everyone but Shelby, as the jury returned a verdict 11-1 on all 3 counts. First, they unanimously found there were aggravating factors, and then on a count of 11-1, they found that they recommended the death penalty. There was one holdout against the death penalty. But in Florida, it does not require unanimous decision to get to the death penalty, only on the guilt phase. That was established, and now he is officially going to be on death row. There's a couple proceedings that have to happen procedurally before everything happens, and the judge formally accepts the recommendation of the jury because it is just a recommendation, and the judge is not required to go along with it, but it would be a very rare situation where he doesn't. So sentencing will be in December. think this might be a quick verdict. If there is, I'm excited to play the verdict music. We'll keep the audio on here, and let's see. Let's stop down there. See if we have anything else that we can watch on. I was liking Judge Wolf. Let's see if he's still doing some fun stuff. Judge Boyd is active as well today. She's got a lot of people there. Let's see what she's doing. Well, she's on break. Judge Wolf is not on break. Let's jump there for a minute while we keep
talk about them, because otherwise, if for example, you make her an offer over something that you contest, that you should even have to pay her, and you make an offer to try to just say, I'm going to get rid of it, so I'm going to offer her something, and then she turns it down, and then you come to court and she brings up the fact that you made her an offer when you said, well, I wouldn't have offered her that if I'd have known she was going to try to use it against me. That's the reason.
Understood, Your Honor.
By allowing people to bring in what they discuss in settlements inhibits and reduces the chance that people will actually settle their case. So as a result, there's a rule, it's hard and fast, no settlement negotiations can be considered. Now, you can talk about what you believe is fair. You can talk about that, and you'll be able to testify about what you think is fair and why you think it's fair. But the fact that you may have made an offer and what her response was is not admissible. Okay?
I still hear that ringing too.
So what I believe fair, Your Honor, is an equal split down the middle. We've been married we were officially married for 9 years, a little over now since divorce has gone for so long.
How long have you been married?
We were officially married for 9 years, so from 2012, yes, sir. And then now that we've been with regard to the divorce and everything, it's been another couple of years. But yeah, that's I believe it to be reasonable to go down the middle, and I asked for equal time with my children. That was really my only ask. As far as the division of debts, that can be, as far as I'm concerned, that's up to you, Your Honor, at this point. Our property is more or less already been agreed upon. Just a matter of me picking up some of the things that I have left at that in order for us to just to pick those up. And they've been locked up ever since this started. So.
All right. Then let me hear from Mr. Thank you.
Judge, respectfully, what we are dealing with here is a gentleman who has brought his children into this divorce. That will be the overriding summary of today's hearing, enough so that we are before this court, and we're going to ask that any visitation that the children have be supervised at this point in time. The parties have an adult child who is actually here in the courtroom. The father brought him. Your Honor remembers that child's testimony. I think it's horrible that he's brought the 18-year-old to court. The court's going to hear today that the 18-year-old barely got out of high school. He missed 31 days of school under his father's care. He was not able to walk at graduation, and the father has done a number on that child with regard to twisting the facts in this case.
Let me stop you for a moment. Mr. Patton, are you intending to call one of your children that's an adult as a witness? He's sitting in the courtroom, and therefore he's not going to be a witness unless someone else is going to call him beside Mr. Patton, so go ahead.
He's sitting in the courtroom, and I just bring that to the court's attention because it is another way for him to try to manipulate the 18-year-old and another way for him to try to make mom out to be a bad person. The court's going to see text messages today between the children and the father where the father is wholly inappropriate with the twins that are still minors, making comments, horrible comments about the mother, buying the kids' affection, offering to take them to NASCAR races, offering to do things for the minor children, passing child support payments through the minor children to the mother, making comments about the mother using child support and how she's using it. just simply not appropriate. And he's done a number on these minor children, enough so that when they come back to the mother for her primary time with the children are angry and upset, make comments to her about have attitude. I mean, they're at an age where they're going to have attitude already.
How old are they?
They are 12. But one text message, Your Honor, is going to see that kind of, as a mother myself, flew all over me because as parents, you're supposed to back one another's discipline. One of the kids mentions to the father that he got in trouble, or she, I'm not sure which one it was, I can't remember now, got in trouble for having attitude with the mother, and the father sent a smiley face emoji, LOL, just wasn't appropriate. At all. So Your Honor is going to hear about some of those things. Your Honor is going to hear about the mismanagement of marital assets also. The father, without the knowledge of the mother, bought a vending machine business. I happened to be in court one day and I heard his name called during the proceedings, and there's been a default judgment taken against, best I recall, there was a default judgment taken against Mr. Patton and his business for vending machines that he had purchased. He told this court, I believe, or he told the other party, I believe, that he didn't know where those vending machines were, and I've got pictures of them on the property where he's hiding out. He's got a live-in female in his home right now who I would submit to the court he's probably trying to make the mother of these children. He has sold, during this process when he was told not to dispose of any assets, he has sold a truck. He has sold a few other things, Judge, and I've got them listed. But I've got the other thing he sold. Give me just 1 minute.
I don't think buying a business is necessarily mismanagement.
Your Honor ordered the car wash sold, and both parties would be responsible for signing off on that. He sold it without the wife's knowledge, and it was sold for about $30,000 under what it should have been sold for. It's originally listed for $430,000, and he sold it for $400,000. I will, so that I'm not misstating anything, I did speak with the Realtor after the close on the business, and that was the only offer that they had received.
I was going to say, there's a limited number of people who would be in the market for a used car wash.
Right, and I agree with
businesses.
that, but the Realtor could not, without a subpoena from me, give me the information I was seeking. So she incurred attorney's fees in order for me to find this information out. It closed, she had a marital interest in it, but it closed without her even signing off on it. Upon information, Mr. Patton is currently working for Hidden Valley Lakes. He was working for a horse farm. He said he was doing all of that for free. We found an item on Facebook advertising the job, and it was about $60,000 a year. He's earning, between retirement and VA benefits, he's earning about $7,000 a month from those, and then he's working on top of that. He's told the kids that he's got big plans for them in the future. He's removed the kids from the state without permission. It just goes on and on and on. Your Honor is going to hear about all those things today. There's a lot of alienation going on, and the kids probably need to be in some intensive therapy.
All right, well, I'm going to go ahead and take my mid-morning recess this morning. It may take a little longer than 15 minutes like we usually use because I've got this meeting with this Utah judge, so we'll stand in recess. Hopefully around 15
Let's go back to the toolbox. Perfect timing.
Bring it back.
Oh, did you hear that? It took the jury 22 minutes to determine if Clarence harbored his son. That's the only thing they had to decide. It took 15 minutes for the police to find him when they first searched his house. Jurors are coming in right now. They had a very quick decision. The one witness in this trial who testified was a police officer who performed the search and found the son hiding in the attic. The son had a warrant for his arrest. The officer observed him running to the house, ran to the house, made sure he didn't go at the back, knocked on the door. Parents came out and said he's not here. Search of the house didn't turn up the son initially. The parents gave permission for them to come in, but it wasn't until they did a more thorough search they found him hiding in the attic under insulation. He was arrested and apprehended, and subsequently the dad has been charged with harboring a fugitive. Defense put on no defense here. They put on no witnesses and based their whole defense on the fact that the officer said that what the prosecution is charging is not possible.
CRB 273, State of Iowa versus Clarence Hurley. Looks like Mr. Prestridge, are you the foreman today? Okay.
Yes, Your Honor.
All right, has the jury reached a verdict?
We have, Your Honor.
Will you deliver that to the bailiff, please?
I'm going to close the poll. You guys voted 77% in favor. I was in the minority, for the record.
Okay, on the sole count of obstructing justice, the jury has found the defendant guilty. Mr. Keys, do you wish to poll the jury?
I was wrong.
No, Your Honor. Okay. All right. We'll take a short recess and reconvene for sentencing. Okay. All right. Thank you.
All right. So once again, I'm found in the minority, and the jury disagrees with me. So there you go. Harboring a fugitive. Apparently, the jury found that there was enough evidence to show that he had, in fact, done that. And it's possible, even at this point in the proceedings, that the defense attorney might ask for a Rule 29 motion in Ohio, which is the equivalent of a judgment of acquittal. Ohio allows that motion to be made all the way through and even after the jury returns a verdict. Basically asking the judge to overturn the ruling because the evidence doesn't support it. So we'll see if the defense decides to go that route. But what is the penalty in Ohio? We'll check this right now. Harboring a fugitive in Ohio, the possible penalty. It's a criminal offense. It can be a felony. If the fugitive is wanted for a felony, the penalty for harboring can be a felony of the 5th degree, potentially resulting up to a year in prison. For warrant or process issued for a felony charge, the penalty can be up to 5 years in prison. It very depends on the fugitive's crime. So if he was speeding, and he didn't show up for court, had a bench warrant for his arrest for not showing up to court, it's going to be a different situation than if he's a wanted murderer and he's in the attic. So we don't know exactly what the want was. Should have taken a plea. Give him 30 days and never do it again. Jennifer, Kerrville. Oh, sorry. No, Jennifer. Hang on. Who was that? Jennifer. Are you still hearing the sound right now? Or is it better now? It went away? So it is coming in on that channel. Ashley, you're hearing the ringing again right now? Like currently? Like when I say 3, 2, 1, 0, now you're hearing it? Not now, it just stopped. Okay. So we are having some weird audio issues on the switcher. That's strange because I've got it completely muted on the high end. How about now? I'm hearing a buzz. There's the ring. I can take the ring out specifically. Does that work? Okay. All right. The ring is driving your dogs crazy. I think I've got it out right now. Let me know if it's still present. I'm not hearing it. So. All right. So Judge Wolf is on break in Tennessee. Oh, look at that. Let me see that. He's got like an extra back.
Court will now reconvene.
We're back. We're back.
Right.
Mr. Savage, you have a recommendation today?
Your Honor, we would ask for a
probation
term of jail time, but would defer to the court on whether that is consecutive or concurrent to the current sentence the defendant is now serving.
Oh, he's currently in jail.
Nothing further.
I didn't know he was already in jail. Guess the jury didn't either. Judge pulls up CMI. It's public safety software. Probably using the version of what's called Justice Connect.
Mr. Keys.
Thank you, Your Honor. We would ask the court, since he is currently serving a sentence, to impose a 90-day concurrent sentence. He is on disability, which I believe since he is incarcerated is being essentially withheld until he is back out. So we would ask the court for that today, as well as minimal fine since he is on disability.
Mr. Hurley, would you like to say anything today?
Do you want to say anything today?
Yeah, I could. Like the video showed, I just woke up. I didn't know my son was in the house. And I told him to come in and search the house. I did not know he was in there. I did not know he was in there. I didn't even know he was there. I was asleep. My wife woke me up, told me to tell the police officer, you can come in and search the house. So I went out there and I told him, you can come in and search the house. But I had no clue that he was there. I didn't realize I could choose to go up here and defend myself. I forgot about that, which I should have.
Defense lawyer is like, it's too late. I forgot I could defend myself in court. Judge trying to think about what to do.
Okay, I will impose court cost. I'll impose, let's see if any credit in this case. I'll impose 30 days jail consecutive to case number 24 CRB 1440. Any question about that?
No, Your Honor.
All right. Anything else, Mr. Savage?
Nothing further, Your Honor.
ineffective counsel and ineffective assistance of counsel. I didn't know I could defend myself. I'm like to testify. Do you see the look the lawyer gave? He's like, seriously? You're going to go there? When the judge asks if he wants to say anything, if he wants to speak, he's not asking him to testify then. He's asking him, he's like, yeah, I should have, I'd like you to consider this or that, mitigating factors. I'm sorry, Judge. I should have owned up. I've learned my lesson. That's what he's waiting for. He's not like, my lawyer didn't tell me I could defend myself. And he needed hearing aids. He couldn't hear the proceedings. What? You sat there the whole time and couldn't hear the proceedings? His lawyer might have a claim for ineffective assistance of counsel. I was asleep. Opened the door. The cops are there. I'm like, what? Son's not here. All right. Consecutive means that he serves. Did he say consecutive or did he say concurrent? 30 days consecutive. It's his turn to throw the lawyer under the bus. And he did. That was quite effective that way. Okay. It's just that channel that has that bad hum. Let's see what Stephanie Boyd is doing.
Say, give me the dismissal. I will sign it.
Yes, ma'am. Thank you.
All right. Is there anything else you need? Yeah, now's the time.
You can always call me too. You can always call me too.
All right.
Thank you.
All right, you're welcome. And if you ever need anything, let probation know. And if you feel they're not addressing it, you can always come back to the court.
Thank you.
All right, good luck to you.
Ooh,
Thank you.
You're welcome.
We're going to do a quick search on the purse and see which one it is. Don't mind me. I'm just checking up to see what purse she has. Looks like a doily.
Hey,
Hanging with Yins. Thanks for gifting a membership. That went to JK Sneakers 22.
Now, he's decided here.
Trying to get a good picture of this purse. The judge needs to move a little bit. Boom, there it is.
That's what's this here.
All right, is the party here on Leonardo Solis Arredondo?
I'm not taking it.
It's got those two loops. Is that Chanel? It's going the wrong direction.
All right, where's your flight? Hi, how are you doing? All right, today is your plea deadline date?
Yes, Judge. As you can see, I'm not Mr. Ashbaugh. I'm standing in for Dirk. He's in trial in Bandera County. I just conferred with the prosecutor. I've at least conveyed the offers to him. He does want time to speak to Mr. Ashbaugh and have him present for that.
All right. Ms. Ferguson, recall this for Thursday.
And Your Honor, it's my understanding he'll be in trial the entire week. He was asking for something after August 11th. I believe he's in trial, and I think he's out of town, but I'm not 100% sure on that. But he did tell me to ask for after August 11th.
All right, so you say he'll be in trial for a week?
I believe so, Judge.
All right, Ms. Ferguson, recall it for August 4th. And that will be your plea deadline date.
All right, thank you, Judge.
You're welcome. Once you sign the reset form, you're excused. And Mr. Arredondo?
Dress nicer. No jeans, hands out of pockets. Judge goes mute. She's giving him some sound advice, I think, right now. Which, off the record. You hate her purse, love her flowers today. I can't. It's a Michael Kors. The purse is a Michael Kors. Peter Tupperware, seems like just yesterday I found y'all. Peter, look at this, 27 months. Thank you for your support. Quick update on me, as I have to pack at some point today because I have to get up at 3 o'clock in the morning to go to the airport. Now, why would I have to get up at 3 o'clock in the morning? Well, because my wife picked the flight for me. So she's like, this will save us $10 if you fly out at 3 a.m. No, it's like, I don't know. I get up at 3. It's an hour and 45 minutes to the airport.
Just go to anyone. Sometimes you go in there, you don't have to talk to anybody.
2 hours
They just welcome you. They have coffee and donuts, and you can just sit there and listen. And then just do the first one, then do the next one, okay? And if you need any other help with that or some type of inpatient facility or something like that, if you come back to court, if your attorney doesn't have any objection, I'll pick up the phone, call somebody and see if they can put you in an inpatient facility, okay?
She's getting them some help.
All right, so I'll see you back on August 4th. Once you sign the reset form, you're excused.
That's awesome. All right, so let me turn that off for a second. Josh has sent me something that I'm not sure if I can find. Hang on one second. Okay, it was... an hour ago.
And then at some point, did you receive?
Okay, here we go. I think I found it. I think we got it. Let's bring this
Yes.
Oops, hang on. We need to go back to the beginning.
Sorry.
New courtroom.
Morning, Judge.
Never been here.
Speaking on behalf of Susan Lapkus. Mr. Marnoka is in the front row of the gallery.
I talked to him earlier. Come up, sir. This is case number 2421004CH. And we're here on Mr. Williams's motion to hold Mr. Marnocha in contempt of court. You can go ahead with any opening statements you want to make, Mr. Williams.
Thank you, Judge. Yes, you've correctly identified why we're here and described it. In the body of the motion, I lay out, and then there's an affidavit from Susan Lapkowitz explaining what hasn't happened. We settled the case, Judge, entered a consent order by stipulation, placed a settlement on the record, and the nuts and bolts of it were that the property would be listed and sold. We identified the realtor, agreed upon the realtor, and the only interim step was that Mr. Marnoka wanted to list or offer the property for sale, probably offer the property for sale on Facebook or over the internet somehow. I think it was by Facebook first, and then we would proceed to the listing and sale. Mr. Marnoka did not go through that initial phase that he had requested for reasons not clear to me. And when we got to the end of that period, Mr. Miller was still in the case. called him and asked him, you guys ever going to get the first listing done or the offering on Facebook? Mr. Miller explained that his client wasn't getting it done and apparently just would not. So then we moved to the next step of asking Mr. Moeller to list it. So I contacted Mr. Moeller. He immediately got listing agreements out to the parties, to Mr. Miller. My client signed, Mr. Marnoka did not, and he and Mr. Miller separated. So Mr. Marnoka has not had an attorney since that point at which the listing agreement was provided to him. And Mr. Miller let me know as he was leaving the case that Mr. Marnoka wasn't going to sign the listing agreement at that time. Of course, it could change, but it didn't. Up until, I must tell you, Judge, last week, Mr. Marnoka signed the listing agreement. Just last week. I think, and I have Mr. Moeller here to testify and explain to you what happened in the last week. But the listing agreement has now been signed. It took from the first week in May, after filing the motion, till last week to get the listing agreement signed.
This one's from Josh. I think it gets better.
And then let me cut to the chase then, if you will. So Mr. Marnoka already has been in contempt of court by failing to do the Facebook listing or offering, failing to sign the listing agreement, requiring us to file a motion, send it to him, schedule it, and it was scheduled out quite a ways, wait till the week before. He did meet with a realtor and sign the listing agreement last week. So now Mr. Moeller can go through the listing. He hasn't made it public yet. He wanted to wait till today's hearing, see if there's any further instructions. And the point we're at now is Mr. Moeller can list. He can offer it for sale. What we're fearful of, me, my client, and I think Mr. Moeller, is we're going to go through the same thing with Mr. Marnoka. If we get an offer, there's still going to be no agreement, no willingness to accept. So I would like to request, and this was what I'll do after I put on some testimony if I need to, with Mr. Moeller and maybe Mr. Marnoka, is that you hold him in contempt, fine him, assess him the attorney fees and costs that we've incurred. I looked it up before I came in. It was $1,400 through May, and then whatever it is for last week and today. So it'll probably be about $2,000 without nailing it down to the last minute. So we asked that be ordered and that he pay it. And that he not impede or interfere with the listing and the sale. He cooperate with Mr. Moeller. And then I think we would like to have it so Susan Lapkowitz can sign without him, but perhaps after, if any offer comes in, we're supposed to tell him, just as we would any other way, seek Mr. Marnoka's approval. If we get it, the sale happens. We don't have to leave him out.
They're trying to sell this house.
If we get an offer, we show it to him. He doesn't want to agree, but Susan and Mr. Moeller both think it's reasonable and it should be sold at that. I would like order of the court that if 2 out of the 3, meaning Susan and Mr. Moeller, think it's reasonable, Mr. Marnoka refuses, that we be allowed to go ahead and sell. Or if you're not comfortable with that, Judge, if we get to that point, then you could order him now that, order now that if we have to go through that in order to have the sale approved by the court, we can do that. I don't mind, we can come back, but I don't want to have to come back to do that if I don't have to. And I'd like to have you let him know if we're going to do all that, he's going to pay again the cost for having to come back to get court approval of the offer if he won't give it and both my client and the realtor think it's reasonable. That's where I'm heading, Judge. I do have Mr. Moeller, the realtor, here to testify if you'd like to hear from him about the last minute development of it being sold and whether or not he thinks there's anything special he needs in order to complete the sale.
A couple quick questions for you. I don't remember from this case is the property that's to be sold, is it occupied by either individual? Is it vacant land or what is it?
It's their cottage property on the lake in Newaygo County. They both are from out of state. So their residence is each has a residence in Indiana. Indiana, not Michigan. So it's not a home site. Mr. Marnoka has been using it, has been there much more often the last 8 years than my client. I don't think she's been there in 8 years.
Okay.
Any other questions for me, Judge?
No. Not at this point. So, Mr. Manoka.
All right, let's hear the other side.
Mr. Williams has witnesses here to testify as to what happened, and we can do that if you want to do that. But I think maybe we can shortcut things into a few questions. So, do you agree that you did not list this property for sale on the local Lily Lake, Whiteley, Michigan Facebook page?
No, it's still listed on our Lily Lake. It's called Lily Lake Owners Group, and I put pictures up and things, but you know, selling a cab.
Hang on. So you did put it up there, and then you didn't get any offers.
No.
Okay, fair enough. Do you also agree that after having it on this local page for 21 days that you were supposed to list it with a Realtor?
The issue with that is I was told I was sent an email with these documents to sign, which I never received. Then my lawyer, instead of picking up the phone and saying, hey, you need to sign this and get it back, there was no communication from Miller to me, none. And plus the listing was in January. Who's gonna buy a cabin in January? Nobody. So that seems fairly limited fairness to me on that situation.
I should try my Starlink before I fly out.
If contacted me better, or him, or this guy, I would have signed the documents. But now I'm getting treated as a criminal because I own a cabin. And I think this contempt of court is uncalled for because I never received the documents he's saying as far as signing it. Because I know I have to sell the cabin. I realized it a while ago, but somehow I did not get that email with his documents.
Okay, it sounds like we need some testimony. You can call your first witness, Mr. Williams.
Yes, I'm going to call Mr. Moeller.
Okay.
Please step forward.
Okay. Nothing like families fighting over property.
All the way up.
Raise your hand, please, sir. You solemnly swear to affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God. You have a seat, sir.
Would you introduce yourself to the court, please, by telling the judge your full name?
John Moeller.
And your, pardon me, what's your professional occupation?
Real estate broker.
You speak up. Are you able to hear him easily, Judge?
Patricia, I've tried to tell you several times. I ate most of them.
And in that capacity,
Like
were you
bison.
contacted about this case some time ago and informed that there was a court order that you be selected as the Realtor to sell this particular property?
They were delicious.
I was
I didn't know they
contacted
were
by
for a
you, Mr.
podcast.
And then at some point, did you get a copy of the court order and a request for a listing agreement?
Can't remember if I got the court order, but I got the appraisals and drafted the listing contracts. I emailed one to you and one to Mr. Miller.
You remember about when that was?
The magnets
Yeah,
are
it's been a
strong.
couple months, it seems, or more. I can't remember the date. I'd have to look at the contract.
And then did you get the listing agreement back signed quickly from Susan Lapowitz?
Yes.
So I have in the motion that on March 27th, John Moeller provided 2 listing agreements by email for Susan to sign. Does that sound about right to you?
Yes.
And then on April 4th, John Moeller confirmed that defendant James Marnoka had not yet returned the signed listing agreement.
So these are
We have an
siblings,
affidavit
right?
from you to that effect filed with the court. Okay. Then from April 4th until last week, did you ever hear from James Marnoka?
No, I didn't, and I did not have any contact information for him. My communication was sent directly to Mr. Miller, and then a handful of times I would touch base with him and see if he'd received the contract, and he told me that he had not.
What are those doors?
Haven't gotten the listing agreement back, or seen the contract.
Windows.
So then when did you meet Mr. Marnoka?
He called a week or two ago. We set a date. I guess it was a couple of weeks ago. We set a date to meet last Wednesday. I went up to the property, visited with him.
Slow down just a second. You said he called you?
Yes.
Did he have any idea what he was calling you about? I mean, how did this conversation start when he called you?
He called, introduced himself. It took me a second to replace what he was calling about. And then we talked about the property, and we scheduled a time when he said he was going to be up here, which was last week, Wednesday. And then I met with him.
And in the phone conversation with Mr. Marnoka, was there any mention of signing the listing agreement?
I think we talked about getting it signed. I think, maybe he was a little apprehensive. He doesn't know me. But when I got up there, he signed it.
Did he offer you any explanation as to why it took a couple months to get it signed?
He said that he never received it from Mr. Miller.
How did he know then to come up and meet with you?
I don't know.
Okay. Did he sign the listing agreement out at the property with you?
Yes, he signed 2 listing agreements, one for each property and a seller's disclosure and a lead-based paint for each property.
Did you get everything signed by Mr. Marnoka that you needed signed in order to go through with this listing and sale?
Yes.
How long do you think you met with Mr. Marnoka?
It's at least 2 hours. I'd say somewhere between 2 and 2.5 hours.
And for most of the 2 hours, what was going on, or what were you discussing?
A lot of information about the property, the history, a lot about, how this all transpired, and the, this whole issue of listing the property, and a lot about, Mark not contacting him or getting a hold of him, and that type of stuff.
Did Mr. Marnoka seem to understand that he had agreed to list the property?
He didn't seem to have any problem listing the property. I think he's just real frustrated with how things happened and came down. But I didn't have any issue getting him to sign once I got there.
Okay. Couple little details. You mentioned 2 listing agreements, 2 properties. Is this really one property with one main cabin and then a side lot?
Yeah. One of my biggest concerns about being able to get the property sold is that they were appraised separately. And
Mel,
the listing contracts are to list them individually and sell them individually. But because the smaller cabin is not in great shape, or the big problem that I think that we're going to run into is that the power, the sewer, or the septic, I guess it's the power, the water, and the septic all come from the main cabin. That does not have a standalone electric, standalone water or sewer. So they all share those, and they all come from the main cabin. And that's gonna make it very difficult to sell them separately. There's only one driveway. And with the prices on the appraisals, I think we're gonna have issues selling them separately. My recommendation would be to put them on the market as one, at one specific price. But if you add the 2 appraised values together, I think we're going to have a difficult time getting that value.
So your recommendation will be to sell it as one piece, right?
Yes.
And did you have any objection to that from either Mr. Marnoka or expressed by my client?
I don't think so.
Okay. Then if it's sold as one piece, one parcel, for all the reasons you just described. Do you expect to list it and sell it as one piece at a number less than the two appraised values combined?
I think we have a very difficult time getting those combined numbers. Which I think is 365.
What's 365 for the whole thing, right?
Correct. I think the one was 275, the main cabin, and the other one was 90,000.
So if those two add together at what did you say, 65?
365.
365, what's your expectation right now from what you've seen and learned about the property as to what you would think it should list at?
You know, I haven't run the comparables because I wasn't sure how this was all going to go. I see there is another place for sale on the lake on the north end. I think we'd be stretched to get 300 for both of them. Ooh. And I think that would be on the high side, to be honest.
Okay, so from that, I would take or infer that you would expect to list it probably at 300,000.
I think we can start there and then kind of see where to go from there.
All right. So then if the parties get an offer at 300,000, would you be recommending or expecting to recommend to them that that's a great offer and they ought to be able to take it?
I would think so, yeah.
And then below 300,000 is just going to be a case-by-case, offer-by-offer basis of whether or not it's worth it or not?
Yeah, I mean, if it sits on the market for months and we're not getting offers or activity on it at 300,000, then I think we're going to have to discuss other options. I mean, we're halfway through the summer right now.
In your meeting with Mr. Marnoka, did you get any feeling that he would or wouldn't be willing to sell if you actually got a reasonable offer?
I think obviously when you get an appraisal, he wants to get the appraised price, I would think, but I think we did talk about the price on the smaller cabin that we both talked about, that it was probably not an achievable number.
Do you think you'll be able to list and sell the property and get Mr. Marnoka's approval on a reasonable sale offer, or do you think the court has to order that he no longer be allowed to have final approval for the sale?
You know, I'm thinking he probably wants the appraised price, just like most people when they have their property appraised. You know, what he's going to do, I'm not certain, you know, but I do know he mentioned that we talked about the number on the small cabin not being a realistic number.
So he can speak for himself, but from what you could tell, do you think you need the court order that you can sell without Mr. Marnoka's approval, or do you think you can work with Mr. Marnoka and if it really falls apart, we can come back to court?
You know, that's going to be really up to him. I mean, I met him for 2.5 hours. I don't know what he'll do. I mean, I know he wants the appraised value.
Okay. I don't have any other questions of Mr. Moeller.
Okay, Mr. Marnoka, now it's your opportunity to ask Mr. Moeller any questions. If you have any questions for him, you'll be given an opportunity to tell your side of the story, but do you have any questions for Mr. Moeller?
Not really. We had discussed pretty much everything and.
Man, so that you're giving your side of the story, but do you have questions for him?
Let me think here. Specifically, maybe not. No, he basically told me what we talked about. And, you know, I want to bring up other things, but I can't do it there.
So, Mr. Moeller, from what you've indicated, the two cabins share power, water, and septic, and a driveway.
Correct.
Have you seen circumstances where potential buyers are hesitant to get
I'm
in a
about to buy
situation
this
where
property
there's
just to get the process to
shared
end.
access and shared water, septic?
I can't afford it. So.
Having to put together legal agreements for easements and what happens if it fails.
Alicia, welcome.
Repairs and all that kind of stuff.
It's going to be very difficult. You know, the smaller cabin hasn't been really used in years.
We might head up to Thurston, Washington
I think
here in
he
just a
mentioned
second.
to me that, it's been quite a long time since they've even turned the water on to it. I think the power was onto it, but the water hasn't. I can't remember what he said, maybe 8 years since the water's been turned on. The cabin's very small. I would say somewhere in the 500 square foot range, and just hasn't been used.
You want $300,000 for a 500 square foot cabin with no water and
It would be
shared
extremely
septic?
difficult to sell, especially if you put it on the market and the main cabin sells and the other one doesn't. It would be very difficult to get somebody to go in there and put a well in the septic, and there's neighbors on each side and the setbacks with the wells and the septics, and it's on the water, so then the possibility of an above ground system goes up drastically. I would think it's best to sell them together because of the potential problems that could be arise if one sold before the other.
Good realtor advice.
Putting the new driveway in, that little cabin appraised at $90,000.
And with that, we're going to bail on the real estate court. We're going to bail because we're going to head up to Thurston in just a second. Here, just a second. Josh, it was a good try, but we'll pass. We'll pass on real estate law. It just is not intriguing to me. Oh, this guy's back.
There's no way we're going to get a 2.25 interest rate in today's world. So the chances that, it's getting into another home at this point in time is going to be very difficult for anybody.
This is divorce. We're going to skip that one as well. We've seen enough divorce today. Let's go up to Thurston. Court 4 is where we were. This is the protection order. That's not the one we want. Thurston Court 4 is live right now. Let's go back just a teensy bit. Okay, let's go here. I'm not hearing anything yet, but Brandon, Jerome, or is that Jeremy? Would it be Jerome or Jeremy? Josh says, okay, I'll take my first strike. First strike. No, we'll never know about the cabins. They're both for sale. You can buy them. I tell you, this is an inside scoop. The realtor would be surprised if it sells for $300. You can go in and lowball them. They've got it for $360. You can lowball them. Come in with like a $285 number or something like that. You can probably get it for under $300, and get all the cabins together, and then problem solved, case dismissed. So, and you've got 2 cabins on the water with 1 septic. All right. Buyers are liars and sellers are yellers. Yeah. What lake is it on? It's on a lake. I think it's Lake Michigan, Upper Peninsula. I think it's the big one, right? Spoiler alert, he was held in contempt. Josh was like, just to redeem myself. Well, look, lawyer shows up in a nice blue suit. Client shows up as well. Still not getting audio. Lake Superior is the big one. Lake Michigan's on the west side of the state. I'm terrible with my geography. Hello, Crystal. Welcome. Hope we didn't wake you. What are we waiting for, and why don't we have audio? we have to skip ahead till we get audio? Okay. Apparently everyone's just joining right now. The guy who's standing in back, just walking around on his phone, makes me think that court's probably not in session right now. They're just getting everything together. Judge isn't on the bench. Let's see, Samsung's here. Oh, it's our favorite. Isn't she our defense attorney? From our office this time, not from our house. Oh, this case can be called later.
Hello, good morning. Can someone hear me?
I can hear you, ma'am. Just fine.
Yes, I can.
Crystal can hear you.
Good
Crystal's
morning, Mr. Rowe. I can hear you. I'm not. Is this the right courtroom?
Who is speaking? Miss Floyd?
Yes.
Yes, this is the right courtroom.
Okay, perfect.
I wanted to make sure the courtroom can hear me. Can anyone in the courtroom hear me?
Brandon refuses
When
to.
I joined, it said that we were being assigned to breakout rooms. But it also showed when I was logging in that it was like a like
Yeah.
Hello?
Hello. Miss Rowe, I hear you.
Madam Clerk, can you hear me?
Paging Madam Clerk. Defense is wondering where his attorney is. Client's here in suspenders. The brown pants just walked out of the screen. New courtroom. Who this? This is Thurston County, Washington. Courtroom 4 this time. We've been here several times for a few small trials. They're a lot of fun. Miss Rowe has a stellar record in defense as well. That's her in the top left-hand corner. She sometimes logs in from a very cluttered home, I think. Jerome is not happy about being here. I think he's on subpoena. These are all pleas and continuances. Well, maybe we need a little light-heartedness here. I do think Colonel Sanders comes in a minute. Watch for him. Like the KFC chicken guy. Jerome's out. He's gone. We're looking up in the corner. It's like a visual illusion. Are we looking into a box, or are we looking at the outside protruding corner of the box? Just depends where the light's coming from, right? Miss Rose can get the audio fixed here. She's on it. Nope, she's gone. Never mind. I take back everything I said. What are they called in England? What are suspenders called? I mean, like the over-the-shoulder pants holder upper. Braces? Like the same thing you put on your teeth? To straighten your teeth? And what would suspenders be in Britain? Okay, we're going to fast forward until we get some audio here. Ms. Rose back. Sanders. Mr. Sanders is going to show up. I knew he was here. To hold your stockings up. That would be like a garter, right?
I'm sorry to bug the court, but can somebody in the courtroom say something so I can know if my sound is working?
Brandon's like, I can hear you. We just can't hear them. Please don't change the channel. The sock things are garters. Say something, I'm giving up on you. That's a good song, Ricky C. I like that one. A garter belt is used to hold up women's stockings. I used to buy them because you don't have to pull down everything to pee. All right. I should have probably read the end before I started reading the beginning, but now I know. The house dispute is looking more interesting now, isn't it? Maybe the part right when he gets held in contempt. But there are clearly proceedings going on, which would indicate there is a judge here, but he's not on camera, and he's got to be on camera to handle, like, Jerome Brandon. Jerome's case is coming up. Like, here he is. Here's Jerome. Joining Jerome in the dorm, wherever he is. Is airport lounge courtroom? Definitely. This has nothing to do with court, but it's a chore to put a TENS unit on your own back. I've fractured L1 and use it for pain. Yeah, and it's not easy to just lay them out on the mattress and then roll onto them because your back hurts. That's the problem. Everybody pees, but I don't wear stockings. Fun fact. Google says braces. But does it know that you're in England? Huh? Okay, I'm going to keep fast forwarding until we get caught up.
Sorry, Madam Clerk, I had muted after you asked.
We're high speed now.
Preston, can you hear me?
I can hear you.
Okay, yeah, I still can't hear anybody from the courtroom.
We're having audio technical difficulties. They'll figure this out as soon as we call Jerome or Crystal. What's on the wall? Brandon, you can't tease us like that. Show us the whole picture. Looks like some sort of map. A lake in the middle. Okay, we're still going 1.25 speed, trying to get caught up. And now we're caught up. So the man with the braces, are the bracers or braces? He appears to be a defense attorney. Gets his laptop from the jury selection chairs. I'm hearing a little bit of sound. Let's see if it's from him. We might have it fixed. All right, here's RG21008992, who appears to be from the back of a police car. Maybe that's the front. He's an officer for sure. Yeah, it's the front. Still can't figure out how to turn off his camera. Ah, got it now. Good, good. And he's back. Nope, he's gone. And he's back. Maybe he's going to try to unmute. Prosecutor, junior prosecutor's here. His mentor is sitting to his side, his left. Are we on his lap? Yes, we're in a small box he's holding on his lap, and he's peering down through the opening at all of us. I've already deleted whichever court you had, Josh. Let's see, what was that? That was something Wago. What was it? Noego? Noego? I don't know what it was. Josh teasing us, saying that the one he sent us to that was terribly slow and boring is actually getting very interesting. Noego County Circuit Courtroom.
Mr. Pazderka, are you able to hear us now?
Hey, you fixed it, Judge.
Ms. St. Pierre, how about you? Can you hear us in the courtroom?
Getting thumbs up from Brandon.
I can hear you now, and this is Miss Rowe.
Hey, Miss Rowe. Good morning.
Excellent. Making progress.
Now we just need the judge to appear on camera.
Did you find Mr. Goodman?
Mr. Goodman was the one. Not yet, Your Honor. I just sent him a text message. I've been trying to. If the Zoom conference can hear us, though, we could go back to Miss St. Pierre, though.
Crystal.
Did she stay on? Yes, she did. Miss St. Pierre, are you there?
Yes, I'm here, Your Honor.
Great, okay. Obviously, you can hear us now.
There should be a change of plea form in the, hopefully in the judge's folder.
Is she in a tent? Or a covered hammock?
There should be one, Your Honor. Maybe it's still in the signature folder for the prosecutor. I guess we can step back on this for a moment if they need to review it.
Brandon's tired, making all of us yawn. He has a box fan in the window. It's probably hot.
Mr. Van.
Sorry, Crystal, I'm crowding you. I'll move a little bit out of the way.
I'll step back. I'll see what I can do about Mr. Goodman. All right, Ms. Rowe, do you have any cases you'd like to call?
I do, Your Honor. If we could first call the Brandon Jerome case. He's present on Zoom. Mr. Jerome is going to likely be participating in diversion. Is Mr. Jerome, I'm having a hard time with Zoom this morning. Is Mr. Jerome showing on the video? Oh, yeah, there he is. Yes. So, Your Honor, Mr. Jerome is planning to participate in diversion. I sent out the diversion referral on the 17th of July. I'm looking at it on my paper. Unfortunately, they must be really busy because they haven't contacted him yet. I also reached out to them last week and left at least one message on diversion's voicemail. So all we're simply doing is asking the court to reset a future hearing, and hopefully by then he will have been contacted by diversion and be participating in it. He is currently in treatment at Northwest Recovery in Lacey.
City?
I'm sorry. I was looking at the same period. The state's understanding was we were going to be entering diversion today. However, I understand that it sounds like they haven't got back. I would encourage Ms. Rowe to touch base with the diversion people before close of business today. That way, if we need to move a date beyond what she's requesting, then we can do that as soon as possible.
Months. Oh, gee.
Okay, let's get a new date for disposition then.
And I will do that, Mr. Thompson. Thank you.
Josh, I'm trying to find the part where he gets held in contempt.
Ms. Rowe?
August 22nd. That should be fine.
3 weeks or so. Okay. All right, Mr. Jerome, we're going to reset you for August 22nd to enter your diversion, and just make sure you're in good contact with Ms. Rowe and that you're there when the diversion coordinator attempts to get hold of you.
Yeah, that'll be at 9 o'clock, I'm assuming.
And just for the court's information, I did, on the referral, I did give them his phone number and his email.
Mr. Jerome, 10:30, 22nd.
10:30, okay, thank you. On the 26th, okay. All right, and I'll be looking out for emails or phone calls. I have not received anything, so, okay.
Okay, you're good to go, Mr. Jerome.
Jerome,
thank you. Have a great day, everyone.
And Your Honor, if I could next call the Elise Floyd matter. Miss Floyd is also present on Zoom. Your Honor, Miss Floyd is currently participating in drug court. And last week, I have been reaching out to, his first name is Brendan, the drug court DPA. I'm trying to potentially see if there's a resolution that I can negotiate with the state to either join these cases in drug court, or at least I'm really trying to discuss some negotiations with the DPA from drug court. I called him last week twice. Friday, just before 5 o'clock, I received an email for him. So I'm asking the court additionally on this case to give us a little more time. Miss Floyd is currently participating in drug court and doing well and is in total compliance. I just need to try to connect with the DPA in that court and see if there's some resolution that can be worked out on Miss Floyd's case.
I'm sorry, Ms. Rowe. I just want to make sure the state understands. You're requesting to talk to the drug court DPA about the district court case.
That's correct.
Yeah, that won't be happening.
Okay.
State's perspective, drug court has nothing to do with district court's cases. They are wholly separate.
All righty. Then what I will need to do is to set a hearing so Miss Floyd can resolve her cases if need be outside of drug court. Did the court hear that?
Yes.
Yes. How much do you think you need to do that?
I say 2 weeks should be fine.
Might jump over to Thurston County too.
I would say 1 week, but I believe I have trial next week potentially.
Let's go down to 2 and see what they're doing. Sorry, need to jump. Hey, Christian Double D Calvert. Christian DD, is it double D? How do you pronounce that? This is a new judge. I haven't seen this guy. He might be a commissioner acting as a judge. Alyssa's likes double D's. Christian was just chilling.
Any other councils ready to go?
Mr. Botello, Judge.
All right. And what docket are we on?
Botello was on for
Chad.
9 a.m., Judge.
9 a.m. Thank you.
Bunch of people in court.
No, my computer's giving me severe issues this morning. I have to basically restart it every 10 minutes or so to get my Wi-Fi back.
Oh, great.
It's going to be a bit of a nightmare. Sorry.
You need a new computer, maybe.
All right. This is Michael Botello.
Yes, sir.
All right. Good morning, sir.
Morning.
All right, council, how are we proceeding today?
Judge, we're hoping to proceed with a stipulated order of continuance.
All right.
Aaron's got the purple paisley tie today. Bold choice. Looks good.
All right. I do see that in my file here. Any record you want to make, sir, before I inquire your client?
No, Judge. I had a chance to speak with Mr. Botello today, and last time he was in court, it appears that his license was suspended back, allegedly. Before the court proceeds. Back east. And, Mr. Botello understands what the implications are of taking this stipulated order of continuance. I don't believe he has any questions.
All right. All right, Mr. Patel, I'm going to go through this document with you. It's this 6-page document called the stipulated order of continuance. Did you go through this with your attorney?
No, I didn't.
Sure. Step out and call my son real quick.
Well, yes, somewhat, but I didn't know it was 6 pages.
All right. Can you look at it on the computer there, or do you have a copy of it in front of you today?
I can show it to him again, Judge.
All right. It's very important that you understand this document because this is kind of a contract that you're agreeing to engage in. So I want to make sure that you've gone over this with your attorney, you understand it. So we'll give you a moment to look at that on your attorney screen there.
Well, him and I did talk about it about half an hour ago.
Okay. Well, he's going to pull it up there for you. Make sure that we're talking about the same thing.
Pardon me? No, I have no questions, Your Honor.
All right. So, Mr. Patel, did you have a chance to look at the document on the computer screen just now?
Yes, sir.
And did you go over that document with your attorney, Mr. Sabian?
Yes.
And did you understand what this document is, basically?
Yes.
All right. And I mean, looking at it, it looks like you're charged with driving while suspended in the third degree, and you are agreeing, or the agreement here is that for the period of the next 12 months, if you drive without a license and insurance and don't commit any new law violations, and that you obtain a driver's license, at the end of that period, the city is agreeing to dismiss this case. Is that your understanding?
Yes, sir.
All right. And then on the other hand, though, if that doesn't happen, if you get more criminal law violations or don't get your license or don't otherwise comply with your side of things, there's not going to be a trial in this matter. You understand that? And at the end of that period, we're just going to have another hearing, and the judge is going to read some police reports and so forth and determine whether you're guilty or not, just based on that, not on an actual trial. Do you have any questions about that?
No, sir.
All right. Anybody make any threats to get you to enter into this agreement today?
No, sir.
Anybody promise you anything other than the case being dismissed if you comply with items?
No.
All right. Well, I find that you are entering into this agreement knowingly, voluntarily, and intelligently. I will sign this document as well. Copy that I have doesn't have any signatures on it. Is Mr.
Sean, I was hoping you could approve Mr. Botello's and my signature, or electronic approval.
Okay, you're having trouble signing it, or?
Well, when we do, then we send a copy to the city. For some reason, they can't approve it on their end. But if the honor wants, we can do that right now and send it to Mr. McClellan.
We could have everybody's signature on this.
Yeah.
Agreement, so could do that.
Yeah, I know that's ideal, and there's some, and I'll certainly try again. Sometimes the format when it comes to me, it won't, signature doesn't
save on the document, but so the court has been able to acknowledge the approval on the record, but I can certainly try again if it gets sent to me.
All right, do I need to close mine out before it gets sent over, or?
Yeah.
It's not been signed by anybody yet.
I just sent it to Mr. McClellan.
You just sent it to Mr. McClellan. He's gonna.
But I saw the version Mr. Stevens sent me that's signed by, or at least electronic indication of approval from him and his client. I tried to add the same. It didn't stay on there, but I think defense signature should be sufficient. I can make a record that the city's, I have reviewed that same form and it's, we are in agreement.
All right, sounds good. I'm more concerned about the defendant's signature on there, so that's. Is there another one, or is there? I'll look at it again. I close out of it just so that I wouldn't screw up the system. And nobody's signatures on that one.
So I think I'm going to jump back just briefly.
The old-fashioned way, we're going to print a copy out. I'm going to sign it. That's how we'll know it's 6 pages long too. So you'll have a copy of this when this is all done.
We're going to jump back just briefly here.
Spell your last name for the record.
James Marnocha, Marnocha.
He's a bit of a stick in the
Thank
mud.
you, Mr. Marnocha.
You're going to hear there's some issues here.
Do you remember when you posted or listed the property on the Facebook page?
Not exact date, no.
Do you have a month in which you think you did it?
I think it was February, somewhere February, March, something like that.
You remember in the settlement agreement, you had 21 days to do so and you didn't do it in the first 21 days?
I guess, as I said, I don't know the exact date that I put it on the Facebook page. I put a written notice up first, I believe, and then I posted pictures.
You admit you didn't do it in the first 21 days like you were required to?
I guess, yes.
He's stubborn.
But nevertheless, at some point you posted it on that, is it a Lily Lake Facebook page?
Yes.
And you added some pictures later.
Yeah.
And no offer came in from that, right?
No.
No offer came in?
No offer came in.
And then at some point, did you receive the motion that I filed in this case asking to hold you in contempt because you didn't sign the listing agreement?
No, I got what you mailed me like a month ago for this court hearing. Like I explained, I didn't get the thing for Mueller to sign, and then Miller never followed up with a phone call.
So then when the paperwork came in from me and you saw that you were supposed to sign the listing agreement, did you make an effort to call Mr. Mueller and sign it? Or just
shortly thereafter I did.
Last week?
Yeah, it was last week it was last week. And I also contacted another suggested realtor too.
And the reason you contacted another realtor before contacting Mr. Mueller was what?
Just a recommendation. He was local and he was, a good realtor. So.
Is that because you were trying to list the property with another realtor instead of Mr. Mueller?
It was just a recommendation from a friend of mine that owns the meat shack up there. He owns a butcher shop.
The meat
I
shack.
told him the property was going to be forced to be sold. And if he knew anybody that wanted to buy it, then he gave me the contact of the other realtor.
Do you recall encountering Susan outside a bank down in Indiana?
Yes.
Some time ago?
Yes.
Do you remember telling her you wouldn't be signing the listing agreement?
No.
And that you wouldn't agree to or allow the sale?
Well, the reason I was there was because I wanted her to sign a quit claim deed on my property in South Bend because I put her on a trust in case I die, and she refused to do that.
Would it be fair to say then that in the context of that discussion, you refused to, or said you refused to go through with the sale up here unless something else?
I don't remember discussing that. It was an argumentative session in the driveway of the bank, and she said she was going to call the cops on me, and I don't remember discussing the sale that you're talking. That wasn't a discussion. It was about her getting off my lease in South Bend. A trust.
All right, so with regard to the sale of the property up here now, you heard Mr. Mueller testify, right?
Yes.
Just a little bit ago. Are you okay with or are you ready to agree with his recommendation of listing the property at about $300,000?
Yes, it was over appraised.
And then are you willing to cooperate with Mr. Mueller in showing the property and having it listed and reviewing offers?
We discussed that, yes.
And then going forward, do you think you'll be open-minded enough about this proposed sale that you would be able to review and decide whether to accept or reject any reasonable offers if they're recommended by Mr. Mueller?
Yes, I would be in agreement with it.
I don't have any other questions, Judge.
Okay.
Does Judge have some?
So, Mr. Manoka, with this contempt, really, it seems like the issue is that you're saying that you didn't get the listing or anything from Mr. Miller.
No, it wasn't mailed, it was emailed, and somehow I didn't get the email, or it went to my trash, or one of those situations where I never saw it. He never called me.
Okay, never called you.
Nope.
How do you know it was emailed to you?
Because that's what he told me in the email.
Okay,
He told me in the email?
all right. Any idea roughly when that was?
It was months ago. It was right when I believe he dropped me as a client.
I don't know when that was.
I don't know either. I have mental damage. My memory is best.
Was it before or after the motion to hold you in contempt was filed, that you had this, that you told him was email.
I don't know, because I don't know when I was put in contempt.
Well, so, Mr. Williams filed the motion, the court got it May 2nd, is when we got the motion to hold you in contempt.
I'm having trouble doing if that was sent to me or not. I didn't, anything sent to me, I always responded to. I told them, I'm not going to ignore anything from lawyers. I said, I just didn't receive it.
Okay.
So what,
So
the contempt of court was somehow an email and then I got it in writing, which I brought with me, which she sent me.
do you know how long after you got the motion for contempt that you? Well, so, Mr. Williams filed the motion, the court got it May 2nd.
I backed up just a tiny bit because I'm
We got the
improving the
motion to
audio.
hold you in contempt.
I'm having trouble doing if that was sent to me or not. I didn't, anything sent to me, I always responded to. I told them, I'm not going to ignore anything from lawyers. I said, I just didn't receive it.
Okay.
So what,
So
the contempt of court was somehow an email and then I got it in writing, which I brought with me, which she sent me.
Do you know how long after you got the motion for contempt that you were in contact with Mr. Mueller to do the listing?
Well, I just contacted Mr. Mueller last week.
Okay.
His name was in the documents that the lawyer had sent me. No, Mr. Mueller. Williams, I'm sorry.
Okay.
Your Honor, pardon me for interrupting, but Exhibit 4 attached to the motion is an email from Mr. Marnoka to me dated April 21st. And it may help either you or Mr. Marnoka with this idea of communication.
All right, so I can let you ask questions about this. All right. So just going back to put a finer point on it. So you're okay with Mr. Mueller's recommendation that both parcels be listed for sale as one unit
Yes,
for roughly $300,000?
yes.
Okay. What do you think would kind of be your bottom line for what you would take for the properties at this point?
Well, Lapkowitz said I could buy her half out for $175,000, which makes the total price $350. If she,
Okay, but that's not what I asked.
No, what I'm saying is, well, that's what I was offered to buy it out. I told Mueller, I said, well, that's what I would like to get then. If it was 175 to me, then I want to make 175 of it.
Okay.
But doesn't matter right now.
Right.
I totally understand. I will sell it for 300 or whatever the offers are. But I think it shouldn't just be Lapkowitz and Mr. Mueller that determine it's my property. I should have say so.
So so hypothetically, let's say it's listed for $300,000 and somebody offers $275,000.
That'd be the bottom line.
So that's kind of where you're at this point.
Yeah.
All right. I don't have any other questions for Mr.
No more from me, Judge.
Okay.
Can I say something?
Yeah, now it's your opportunity to tell me what you want me to know about the situation.
Okay, well, as far as necessary repairs that require skilled trade, I've done a whole bunch. She's done nothing. I've got a penny for what I've done. And we're talking hundreds of hours and thousands of dollars of time I've put in doing things. And,
So Judge, I
she's done
object.
nothing.
The terms of the settlement require sale and distribution equally. And the parties were left by your direction in order to file a motion after the sale if they need to argue about how to divide the costs that have accrued over the last several years.
So what he's indicating is that that argument about how it should be split is premature.
Right. Okay. All right.
So I'll sustain the objection.
Okay.
So all right. What else do you want me to know?
Well, just that, there was a tree that fell down right in front of the driveway. Blocked the whole driveway in April, okay? I had to go up there, cut it up, and remove it all. Then there's another tree that fell down by the lake, across the fence, which I had to go down and cut that up into chunks. And I'm disabled. Okay, I have neuropathy in my legs, and I'm on disability, my finances are really bad, and I don't think I should have to pay the lawyer fees. Because the contempt thing, to me, I'm getting treated like a criminal and we're just trying to sell a can. And I don't think that's fair. I really don't. I think it should be split evenly, and then for all the work I've done at the end, they will argue that out, just like you said. But Miller didn't help me at all.
Okay. Any follow-up on that?
No more questions, Judge.
Sit down, sir. Thank you.
I'm prepared to argue or summarize my request, which is a little different now than what it was when we started.
Okay, did we sell the cabin yet? Sorry, just got a call from Angela. We were talking really quickly. Also got a message from Phil from TYO Toys. Apparently he was on the news the other day up there on Fox 5. Looking great. It's hilarious. I liked it. I saw Ivan is touting his goat business. This is legit. He called me over the weekend about this, and we spoke in depth about the business model. And there's I kid you not. There's a website
Go ahead, Mr. Williams.
called hiregoats.com.
I withdraw the request to have the court order that Mr. Marnoka not have any approval authority or the authority to approve or reject a sale. I think based on his meeting with Mr. Moeller's testimony, and then Mr. Marnoka's testimony today, I think we should be able to muddle through the offers and acceptance. And if we hit a roadblock, we can come back to the court at that time. I don't think I need an order taking Mr. Marnoka out of the decision-making phase of the offers, or any offers to be received by Mr. Moeller, which would leave only the remaining issue today for contempt. And with regard to the contempt motion, I still ask that he be found in contempt because of his delay in not posting on the Facebook page within the 21 days that he was supposed to, and then not signing the listing agreement as proposed until last week. I'm glad he did, but if you just look at our motion date, Judge, I drafted, signed, and filed the motion May 1st. And he was served with it within a week, and it's gone from May 7th till now, till last week, to get it signed. That's too long, way too long. And I suggest that the only reason it was signed last week is because the motion hearing was today, Monday. So he only signed it, Thursday, Friday, Saturday, Sunday, Monday. 4 days ago, 5 days ago.
Yeah, that's contempt.
And the order by which we sold had right in it that he had to do the Facebook listing which was his request, and then it would be listed with Mr. Moeller. Mr. Moeller was identified in our settlement order as the person through whom this would be listed. So the explanations from Mr. Marnoka just fall short of being factually accurate about his responsiveness. I can't say anything about how well he and Mr. Miller communicated. I just can't. But when Mr. Miller was still in the case, I'm obligated to send the listing agreement to Mr. Miller. I can't send it to Mr. Marnoka. And then after Mr. Miller was out, Mr. Marnoka received from us the motion about the listing agreement in the first week of May, to go from May 7th, giving him the benefit of the doubt for time, to July.
This attorney bills by the hour.
Is too long. I don't believe he would have signed if we hadn't filed the motion. So I still ask that he be held in contempt and assess him $2,000 in the attorney fees and costs. But that's it. No more.
Okay, any argument that you want to make, Mr. Marnoka?
Well, the initial argument that I said that I never received anything from Miller. I didn't get an email signed. I would have signed had I received that. Now, like I said, I got emails from 4 different people out of that office. You know, he has his people that paralegals and stuff do a lot of the things, but I did not receive that listing agreement that I signed with Muller. I did not receive it. And I don't know why, but I didn't. So if I don't have it, how can I sign it and give it back? So that's an issue.
Goats don't fall.
I would have signed it, and I'm not going to ignore something like that because it's court ordered.
All right, thank you, sir.
And the judge is now going to rule. Thank you, thank you. I'm looking at this hiregoats.com directory that has all the businesses across the U.S. where you can rent out. Like Ivan's talking about goats. Hashtag goats don't fall. Yeah. There are some crazy names for goat companies. Of course, it looks like a franchise called Goats on the Go, which seems to be all over the United States. But Goatscape seems to be a good word. Goatscape's in there a couple times. Let's see if we can find another good one. I think there was one called GoatWorks. Wendy's got your goat. Wendy's got your goat in Wyoming. That's good.
All right, so the court is going to find Mr. Marnoka in contempt of court.
Goat munchers?
The reason for that is the stipulation in order did indicate the timeline to list the property for sale on the Lily Lake Facebook page. Mr. Marnoka is partially admitted that he didn't do it within 21 days. Essentially, he just agreed with Mr. Williams because I don't think he knew exactly what he did. His original testimony was he put it on Facebook Marketplace sometime in February or March, which would have been within 21 days, but ultimately he did say, hey, I didn't do it within 21 days. And that's, the court recalls from the case, that's something that he wanted to do. I know that the plaintiff didn't want to mess around with that, just gave it the realtor. That's something he wanted to do. It wasn't the court order, but that was going to inure to his benefit. So not doing that was a violation, but I think it was minor. The major issue here is, okay, did he fail to comply with the court order to list the property within 21 days? And that's a harder call because I don't have any facts to support that he got any listing agreement from Mr. Moeller or from his attorney or from Mr. Williams before the motion was filed. That's the testimony I left, that he didn't get any email. So then the next question becomes, okay, well, once he got the motion that alerted to him that this was a problem, did he act within a reasonable period of time after that? And the court would find that no, Mr. Marnoka did not act within a reasonable time after getting the motion for holding in contempt, which then leads me to, okay, what costs were incurred by the plaintiff in the delay? And
that's all I can take. That's all I can take. I have to show you this because this is Ivan's business model here, which is just crazy. Look at this. I think we're on 7, right? So goats on the go. I'm gonna show you this. Apparently, this is like a franchise version. Look at this. This is gonna be Ivan here at the top. You just bring like 300 goats over, and in 10 minutes or less, they mow your entire property. I mean, they're just like as high as they can reach. They're climbing up there. They're standing on each other's backs. This is just wild. This is wild. I'm impressed, Ivan. They even eat poison ivy. I will just by word of warning, Ivan, there are quite a few businesses already up in Wisconsin, so you have some competition. But man, they're all spray painted. Why do you spray paint their butts and spray paint their ears? So you know whose is whose? There's pink herd and blue herd and green herd. How would you move that many goats? Do you need like a semi? $5 already brings a goat with him on his vacation. I'm gonna have it on the plane with me. That's how the Titans football practice field gets mowed. They're called the Chew Crew. Thinking of getting each a blinged out necklace with like a big old dollar sign. I think you should name them after brands of lawnmowers. Barb, that's the beauty of it. You don't have to clean up anything. It's natural fertilizer. It's good for your land. Not all are created equal. Are some goats lazy? How do you know if you're getting a good goat? And maybe you should call it like Billy's Goat Lawn Service or something. Billy's Goat Landscaping. The Billy Goat has to be in there somewhere. Goat yoga is a real big business in Louisiana. Plenty of cheese, too. Been lurking, and hubby says I want to get goats. I said, nope, chickens are all I can handle right now. Oh, come on, Mel. That's the hustle. They fertilize, so they'll eventually need you to call. They'll need to call you back. The seeds work through the system, and you're basically perpetuating the problem. Okay, I'm thinking, Ivan, it's got to be live streamed as well. You've got to live stream your goats. First of all, for their safety. You don't want the goats to be able to get up to shenanigans and you not know about it. Putting the kids to work. Oh, that's so great. There are so many good names out there you can use with goats. Gruff mowing. You could just call it gruff mowing, right? Because Billy Goat's gruff. John's like, I'm not here for the goats. We're gonna go to lunch is what we're doing. I was just I don't know if we're gonna come back, honestly. And here's my reasoning. I have to pack because I drive out at 3 a.m. in the morning to go fly out tomorrow. I'm taking you guys with me, but we're probably not gonna do anything live because it's a direct flight. I don't have any layovers, so I can't do anything live until I land, which will be about, I think it's noon. I think I land around noon. That seems like a super long flight. How is that? Anyway, then I'll be up there. I'll be up there by noon. I think I land at 10. I'll be up there by noon, so we might do something in the afternoon and come on and just say hi, show you the lake, show you where I'm at, and then go from there. So I'm taking half days. I'm headed to Idaho. I'm headed up to Bear Lake, Idaho. All my siblings are having a vacation, a family vacation. We're getting together and hanging out with my mom. And it's the first time we've ever done this. So it's about time. It's about time. I'm the only one who's not bringing my family with me. Everyone else, all the other spouses and siblings are all going to be there. And that's a lot when there are 10 siblings. So anyway, we've rented a supersized mansion. I don't know what's going to fit us. Apparently it sleeps like 80 in one building, in one house. And then we've got a separate house that's pet friendly because we have allergies, going back and forth. The separate house sleeps another 60. So I have no idea. All I know is that I'm supposed to be taking pictures of it of everybody with this camera while I'm there. So I'm the photographer. That's why they invited me. Anyway, Bear Lake it is. I'm planning on. So I have to pack today. Let me give you the rundown. I have to pack today. Like clothes and things to wear. I've already got all the electronics covered. I have to put on the shower door because I just finished mounting the mount for the shower door. It's a big glass bifold shower door. I just finished that this morning, so now the glass part goes up today. And yes, I'm 1 of 10. I'm right there in the middle. Yes, bring clothes. Yes, Idaho. They're pretty open, but not that open, right? I hope to have a very, very safe trip, and it should be wonderful. Flying on Delta, you guys, so if you hear anything bad about a Delta flight between, say, like North Carolina and Utah, that was me. But I think that's it. That's it. We're going to go to lunch. And I'm going to pack. My family's out at the beach right now, so I have no excuse. I have no distractions. My son is coming back from work. He'll be here just a minute. And here we go. Vacation. Here we go. Here we come. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again. Maybe tomorrow afternoon, but for sure Wednesday morning. So I apologize if your birthday's tomorrow. We might hit you on Wednesday instead, but it'll be good. It'll be good. I can't wait to show you the lake, honestly. It is the bluest lake. It looks like you'll think I'm in the Caribbean. You'll think I'm in the Caribbean. It is that blue. So I'm excited for that. All right, will there be a hump day yell? Yeah. I might have everyone join in. I might have them all join in. Cool. All right, be good to each other. We're going to see you. I'm going to start packing and cleaning and maybe take an Advil. I've already got a headache. All right, have a good one. Bye-bye.
It's bigger than you. It's bigger than me. It's bigger than all of us.